Yes.
That has been admitted against the final decree. Now the execution to execute the final decree is pending. It has been fixed to day after tomorrow for issuance of the writ.
Correct.
Second of
I filed a mistake.
second of the 2024 for admission of the second of
Second appeal, you did not mention, it will come on its own. Yes.
To mention, Your Lordship, RSA of 2016, Your Lordship. Your Lordship, interim order is there, but a respondent has somehow convinced the police officer that the judgment passed in the RFA is the final judgment, and somehow they are trying to evict the appellant from the suit property.
No interim order is there.
Interim order is there, Your Lordship, but
Each way the interim order.
they somehow convinced the police officer. Your Lordship, the matter may be taken for the final hearing, Your Lordship.
Yes.
and petition of grammar Rojugar Sebog challenge the order of a disengagement without any opposition of jury.
That is an appealable order.
My lord.
That is an appealable order.
I don't to mention my lord. Word matter, Anganwadi matter, my lord. Disengagement of
RSC 151 of 2018. As per the direction of this court, the matter was to be listed on 29th July, but the matter has not been listed.
I beg your pardon to mention, Your Lordship. This is RSC number 109 of 2010. It has been pending for 14 years, and we have the decree has been, Your Lordship, in the trial court, in the appellate court, in the both court, we have won the case, but in the second appeal, they have currently showing the apprehension to create a third party interest by selling the land. So that's the urgency.
देखिए weak सारा spread over करके नहीं ऐसा accepting institute आ चुका है.
Literally item number 1, election petition.
Petition, my lord, the notice to go in this. But see, wanted a clarification.
Yes. What are you challenging, sir?
The orders. I mean, a respondent appointed one public servant as his polling agent and counting agent.
Yes.
So this violative of the orders of the election.
No, I'm sorry. No, can you please again?
The respondent appointed one public servant as present and counting agent.
I think this was Mr. Samal was
Yes.
arguing.
Yes,
I just wanted that clarification.
So there is a judgment to that effect also, public servant.
I'm new to this law, so I wanted to.
My lord?
I'm new to this law,
No.
so naturally.
Yes.
I wanted to know whether that comes under the section 100.
100.
Whether it-
100 is very clear, my lord. Just have a kind glance to that.
procuring assistance of government servant candidate appointing person as polling, not knowing him to be government servant. It's a mens rea is not the correct term.
But this coming to that 104 by any non-compliance with the provisions of the Constitution or of this Act or of any rules or orders made under this Act. So the guideline that was communicated to the candidate and everybody. In that guideline, it is specifically mentioned the chairman of the panchayat is barred.
Heard Sri Manas Ranjan Mahapatra and senior counsel with Sri somebody, any other name? Mr.
Mr. Samal.
Hearing for the petitioner. Admit. Issue notice. Fixing. What a date karo? 23rd September for filing of written statement and settlement of issues.
Oh, thanks. Okay. Let it be there. No.
Yes, sir. Okay.
This is still good. It has been discussed in 75 case also. There the 75 that put head in that 5 judges bench in Indira Gandhi's case that he was not a government servant.
Okay.
But here there is notification, everything we have found.
Item number 2.
Dispute in the present case relates to 7 Jharsuguda Assembly constituents.
Yes.
The total number of voters are 2,29,274. That
Yes.
is available to your lordship at page 6.
Page Yes,
Total pooling 1,91,199. It's available at the same page.
yes.
Vote received by election petitioner 89,772, paragraph 10, page 20. Vote received by respondent 91,105 at the same paragraph 10, page 20. Margin of difference is 1,300. That is available to your lordship at paragraph 11 at page 21.
Yes.
My grounds of challenge are non-disclosure of 4 criminal cases.
Okay.
By the respondent in his affidavit in form 26.
Is the affidavit here?
No, affidavit will be filed after settlement of
All
this, and it will be called for. Then this session is available to your lordship at page 89 to 90. 4 criminal cases have not been disclosed. Then
These are the cases. These are the cases.
Minor. And in affidavit in form 26, not engrossed on non-judicial stamp paper. With respect to 8 numbers of polling stations, that is most serious allegation, I have given it at paragraph 14K at page 109 to 112. I have given the numbers of 8 polling stations.
Yes.
Here, I have given the numbers of control units used at the time of voting. On right-hand column, I have shown those polling control units were not counted at the time of counting. Some other numbers were counted. And the total votes counted in these 8 polling stations are 6,330,
Yes.
which is disproportionately large than the margin of difference. These are
Proportionately large. How do you say so? There are 8 polling stations.
সেটা 1333 মার্জিনটা
Okay.
এটা হচ্ছে 6,313.
আচ্ছা।
If the same number of control units would have been counted, nobody knows what would have been the
Yes.
result.
All right. All right, we'll admit it. That's with the governor, Mr. Alliance, senior counsel with you are Mr. T.K. Mishra
Man,
with Siri T.K. Mishra. Admit. Issue notice, issue summons fixing kete
requisites have been filed.
23rd September for filing of written statement and settlement of issues.
No.
Yes.
Item number 3.
This is matter on. issue summons kar do.
That this election petition relate to 47 Chandwali Assembly constituency. And the election they have challenged the election of the return candidate respondent number 1, essentially on the ground that he has given wrong information in form 26, and there is improper acceptance of the nomination.
So many respondents.
There are so many respondents because I have prayed for the further declaration that if the election of the respondent number 1 is declared to be void, then the next candidate who has got the highest votes, he should be declared as elected. So therefore, I have made all the candidates as respondent. And essentially, I have challenged that there is no identification of the candidate respondent number 1, and it was identified by the notary That is not permissible under the law. And second, the immovable property which has given the list, all the immovable property are the belong to Hindu undivided family, but is shown in the column of the individual property. That is the second ground. And so far as the movable property, he has not given the proper details from where though he has given the detail of the bank account, that this is the amount deposited in the bank blood of his spouse. But he has also hold the card in the income tax card, but no return has been filed, and he has shown that it's in nil, without specifically mentioning that no return has been filed. That is the requirement. And the election expenditure which has shown in form on 29/6/2000 in form F, in that election expenditure, though the amount has been mentioned, and it has been mentioned that from RTGS, it has been transferred on RTGS. From which bank it has been transferred, that is not, that information is not there. These are the grounds I have challenged.
It is incomplete.
It is incomplete.
All right. Same order. Hello. What's the in case of 23rd? 30th September. Same order.
Item number 4 to be mentioned.
Yes, item number 4. Pass over.
Item number 5.
Pass over.
Item number 6.
People are seeking, already workers seeking remuneration are not given to the formal lot. Attention of before the collector
कौन है जी अंगनवाड़ी worker?
seeking remuneration.
No, what are the facts of the case?
And that is, he was selected and appointed as anganwadi worker. Dinosaur 1 is the appointment selection, and Dinosaur 2 is joining report. Thereafter, there are some he joined there and some distance there because he is the lower caste. The petitioner is a lower caste, so the persons are not allowed to function there. Again, that way, center was function in a club. Thereafter, dispute arose and he cannot. Though he was working there, my lord, made representation to the collector at the annex on 8, my lord, regarding his remuneration.
No, you take instruction. Take instruction in this. This is something that appears to be fishy.
Yes.
She did not join. She was asked to show cause. What I find, she has given a reply. But then,
Another 2 is joining letter, my lord. Another 2 is joining letter.
all right. Let him take instruction.
That is.
It is submitted by learned counsel with the petitioner that despite being engaged as an Anganwadi worker, the petitioner was not allowed to join apparently because of her caste. Stop. Learned State Council shall take instructions in this regard. It's a very serious matter. Our representation disposal. I'm giving you one chance. You may withdraw the writ application, but I will go to the root of it. Caste allow serious violation of the constitution. ଆପଣ ଆସି କହୁଛନ୍ତି ସେଇଟା କହିବେ ତାପରେ କହିବେ representation disposal କଣ ମିଳିବ ଆଜ୍ଞା ମୋର disposal ବଡ ଭଲ କରିଛନ୍ତି ତାହେଲେ let him take instruction. That is why I passed that order. Take instruction.
Yes.
Place this matter the week for
2nd September.
2nd September.
Yeah.
Yes.
Item number 7.
My lord, I am the petitioner.
Yes. Yes.
I'm the petitioner and average petition is filed against me in the family judge court. But it should be September 24. And I am unable to attend the court due to my poverty.
All right. Issue notice. The opposite party by registered post, by speed post. Fixing a short returnable date, requisites be filed. Requisites will be filed by tomorrow,
Okay, sir.
by tomorrow.
I,
Release this matter on
9th September.
9th September. IA. Further proceeding in CP number pending in the Court of Learned Family Judge, Family Court, Rayagada, shall remain stayed till the next date.
Item number 8.
Wife's application seeking transfer from the CP case from Rourkela to Judge Family Court, Keonjhar.
Take notice. Notice, huh? Notice, it is taken. Yes.
Item number 9.
Petitioner is the wife, madam. Seeking direction from the Hon'Ble Court, transfer of CP case from 42 of the from the court of the Learned Judge Family Court, Rourkela to court of the Learned Civil Judge in the titular.
All right, notice, stay.
Item number 10.
Item number 10, my lord. The petitioner is the wife, my lord. Seeks transfer of the case from the Learned Judge Family Court, Bhadrak, to the Learned Judge Family Court, Jajpur, my lord.
On what ground?
My lord, only old father is there. Nobody is in the family.
All right,
To-
notice, stay.
Obliged.
Item number 11.
Page 24, Annex 4. I have been duly selected in Police Sabha and my name has been recommended for appointment by the Police Sabha to BDO. But till date, I'm not able to get the appointment letter. Because of the order, subsequently, while I have inquired into the matter, I came to know that one order has been passed by this Hon'Ble Court as an interim measure to stay the appointment, and the person who was discontinued, he has filed a repentation before the collector and praying came here for with a prayer for disposal of his repentation, which has been stayed, and he is continuing.
I am,
The second
you were engaged as Gasathi or that mate.
I have been selected to
You were
be
selected,
appointed
yes.
as Sagransati
Yes. Then,
on Annex 4. Subsequently, the previous was disengaged, he filed a repentation before collector and came up to the Hon'Ble Court, and this court has been pleased to stay the disengagement.
okay. So that is why you are unable to join. So where is that other date application?
And the second case was
Second,
May I please-
2020.
who is appearing in that case?
In this case,
I am appearing, my lord.
Opposite party number 3, my lord.
Who's for the petitioner? Mr. Panda?
Yes, my lord.
Why are you virtually-
petitioner in
why are you virtually? Why not physically? Anyway, so both these matters can be disposed of.
My lord.
You have filed your counter in this case.
I have filed the counter.
You are for whom?
I am for the Sarpanch, my lord.
Sarpanch.
But I am not a party to that first writ petition.
All right. We'll take up both these matters together. What is have you got your instructions?
There are two orders, my lord, by your lordships, to do the needful with respect to the women Sarpanch and the representatives.
Yes.
So both the orders were complete and compliance affidavits have been filed by the state authorities, my lord. Those are the two the correspondence, my lord, which I have with me. But with respect to the present case, my
No,
lord,
there are two. Let us first understand. There are two matters.
Yes.
He claims that he was engaged, but he was selected for engagement, but he was never given the appointments. Now, the other date application, Mr. Panda's client, he was his predecessor.
Yes.
He was disengagement order. He has come to this court.
yes,
So that is in disengagement order is pending. So naturally, that writ application has to be decided. Your writ application becomes subject to obviously the result of the other writ application.
My lord, that writ application has been filed for direction to the opposite party number 1 collector for consideration of repentation.
Anyway, that is pending.
My lord,
So unless the collector takes a decision with regard to the disengagement of the incumbent,
no order has been passed to that.
no order has been passed. That's right. That's right. Here, this second engagement should not have been made, isn't it?
No. My engagement has been made prior to the stay order.
That's all right. That is all right. So anyway,
But I am not a party to that proceeding.
That's true. That's true.
That both the petition, the petition as well as my application will be sent to the collector. He will decide as per law.
Yeah, what do you say?
I have not said something.
What do you say, Mr. Panda?
My lord, I have never disengaged by the authority, my lord.
My lord, he has
But I was not
the
allowed
affidavit.
to do the work, my lord.
So
I will
refusal
be
of
permitted
employment does it
file
not
a
amount to
rejoinder
termination?
Counter, my lord.
Mr. Panda, refusal of employment amounts to termination.
No, my lord, there is no proper disengagement from the side. of the
Already,
authority.
you come physically. Let us hear these matters and I'll
My
pass
lord,
out.
my lord.
Yes.
My lord, date may be fixed.
Yes.
Let it come next week, my lord. I pray for next week.
All right. Yes.
My lord.
In course of hearing of both these writ applications, it is stated at the bar that the matter can be disposed of finally at this stage. Hence, raise this matter next week. Parties are requested to come ready for final disposal. Yes. We'll dispose of. If it is necessary, then we'll direct the collector to take a decision. Yes.
Item of 12.
This is third round of litigations. And the petition has questioned the order of the appellate authority under Annex 10 and the consequential advertisement issued for filling of that post of Anganwadi workers. Let's see kindly just against Annexure 1. And
Yes.
the advertisement issued for filling of the post.
Yes.
And page 19.
Page 19.
Sorry, Annexure 1, page 16. The first criteria is, what's he got it? Page 16. প্রার্থিনী সম্পৃক্ত অঙ্গনওয়াড়ি কেন্দ্র অধীনস্থ গ্রাম্যর স্থায়ী বাসিন্দা হইতে হবে। I am having this grammar. Then, the page 18, that grammar namo Pandiapalli, last that serial number 33.
Yes.
And the Anganwadi name of the Anganwadi center is Ambahura, that is the hamlet. Then Annexure 2, page 19, I was selected. My name is serial number 29, Ambahura, that Anganwadi centers. Pandiapalli is the revenue village, Ambahura the Anganwadi center. Now some petition are filed by some strangers. And the collector directed to disengage the 11 persons, 13 persons. Only on the ground that the selected person does not belong to the service area. And this order, pursuant to the order of the collector, I was disengaged, that is page 24 on Annexure 5. And 13 persons are disengaged, only on the ground that I don't belong to the service area, though I belong to the other revenue village. So I question it. So this honorable court pass it and remitted matter to the collector for reconsiderations. Again, the collector, page 26, again reiterated his earlier orders. That's kindly see page 27. Page 27 is relevant for the
Yes.
Peruse the document made available on the office submitted by the district social officer. The petition does not belong to the service area of such and Anganwadi center. Accordingly, the petition does not fulfill the criteria, so she is bona fide resident under the Anganwadi area. Hence, I am opinion that the selection made by the selection committee and the appointment successors is improper, and according to my previous order stands. So again, I challenge this. And again, that was passed. Next page. That is page 28, Annex 7. And that matter is again remitted to the sub-collector, who is the appellate authority to decide the matters. That 32, and since both the parties in contest have already appeared, and contest is not, this court direct both the parties to appear before the sub-collectors. It is further directed that position of the engagement of Anganwadi workers in the meanwhile shall maintain for a period of 3 months. Status was there. Now, the sub-collector, let us kindly see, pass the orders. That is Annexure 10. He has made out a different case. I am challenging the order of disengagement. That order was appeared. Kindly see page 41. Different. Page 41, paragraph 3. Sri Inki Katta, the present petitioner, is not working in the Ambahura Anganwadi centers since 2010. I was disengaged in 2009. I challenged this orders, first, second, third litigation, and his opinion is not continued since 2010. So it is a clear that she is no more interested to perform there, and that is also presumed due to long absence, and that she has voluntarily relinquished her post. He said, I am not continuing for I am not interested, so I voluntarily relinquish the post. This order is challenged. This is the application of mind of the collector, sub-collector. So I am again proceeding this.
Yes.
My lord, this orders, my lord, that shows, my lord, Mr. 10, that she is not working since 1/8/2010.
How can she work? She was disengaged.
She was disengaged in the year 2009, my lord.
Yes, and she challenged it.
Yes, ma'am.
Yes.
Thereafter, my lord, she was protected. But during the protection, my lord, when it was granted in her favor, thereafter, my lord, she didn't join.
Now, where is that order?
Now it has been presented by my lord.
Okay, let us see.
Because I do not have any further instruction because this for the first time my lord is coming. But from the record it shows, my lord.
Because when this order was passed, in the earlier writ application, was there any order of status quo or?
Status quo order was there, but that was the date of passing the status order is disengaged. So accordingly, I was not allowed. And lastly, the order was passed and direction not to the appellator to review the matters. Again, twice.
File a counter.
I'll file it.
You file a counter. The counter will be necessary. So now, where is the fresh advertisement?
Annex 12. The last annex.
Already
The order of the sub-collector was passed way back in 2023 July.
23 July.
And you remained content
No,
with
that
order.
was not communicated. My specific time that was not communicated. Though
Where have you said that in your writ application?
Yes. I specifically stated that. Yes, paragraph 12. After disposal of appeal, the said order was not communicated to the petitioners. From the advertising dated such and such, for filling of the post of honorary workers of such and such center, the petitioner came to know that after disposal of appeal, the same will issue the advertisement. Paragraph 12 page.
Correct.
Yes, sir. After the disposal of the appeal, a communication of the order will be there to the respective parties. My lord. That order has been heard in presence of the parties. And he not making a submission, my lord, that the appeal has been heard behind his back.
No.
So if that has been heard, my lord, then a communication thereof will save the limitation.
Limitation. Writ petition, there is no limitation. Within 1 year he has come, or a little more than 1 year after, a little more after.
Challenging that particular order, my lord, of 2003, in the year 2004, when the advertisement has
No, this order.
Yes, so
Sub-collector's order.
2023 in the year 2024, when the present advertisement has been issued. My lord.
So that gives him a cause of action. That is why I asked him, why didn't you apply? He says that I was never communicated. All right. Serious and Patnak learned AGA accepts notice for all the opposite parties. He further undertakes to file a counter and seeks 4 weeks time for the purpose. After hearing learned counsel for the parties, learned counsel for the petitioner, this court would like to know the response of the state with regard to the amendments made in paragraph 12 of the writ application, specifically, along with other amendments. Leave this matter. What's about?
9 September.
On 9th September. IA. As an interim measure, this court directs that selection process pursuant to advertisement number 612 dated 4/7/2024 may continue, may be undertaken, but same shall not be finalized without leave of this court.
If it has not been as on date.
It is to July masere
He
heiche.
agreed notice that they said
Although
that-
the-
Acha, comma, if not already final.
Yes, most of it.
Item 13. May I please? My lord, here in this case, that. My lord, here in this case, I have been. Paragraph 2 Miller, pursuant to our advertisement in year 2021. I appeared the Anganwadi election Miller. Then no declaration was made. Thereafter, in pursuant to the election bill.
What happened? You were selected.
No, I have appeared in the year 21.
Mane,
How?
pursuant to the advertisement.
Pursuant to the advertisement 5/7/21 ରେ ମୁଁ appear କଲି।
Yes.
appear କଲା ପରେ result ସେମିତି ରହିକି ବାହାରିନି। ମୁଁ ତାପରେ 22 ରେ ଯୋଉ ସରପଞ୍ଚ ଇଲେକ୍ସନ ହେଲା ମୁଁ ସେଥିରେ contest କଲି। So I am now declared
Elected.
elected.
Yes.
ତାପରେ କିଛି ବି ଆସିନି। 2000 ତାପରେ 23 ରେ ସେମାନେ ଗୋଟେ ଲେଟର ମୋତେ ଦେଲେ। ନହେଲେ annexure हुआ। Annex हुआ। ଯେ ତମେ ସିଲେକ୍ଟ ହେଇଛି ଏଟା ଦେଲେ 1/5/2023 ରେ ଲେଟର ଦେଲେ ତ ସିଲେକ୍ଟ ହେଇଛ ଆଉ ସରପଞ୍ଚ ପଦରୁ ଇସ୍ତଫା ଦେଇକି ଆସ। ସେଥିପାଇଁ ମୁଁ annexure 3 ରେ ଗୋଟେ ରିପ୍ରେଜେଣ୍ଟେସନ ତାଙ୍କୁ ଦେଲି ଯେ ମତେ ଆପଏଣ୍ଟମେଣ୍ଟ ଲେଟରଟା ଦିଆଯାଉ। ମୁଁ ସିଲେକ୍ଟ ହେଇଛି ନା ସେତେବେଳେ ତ ମୁଁ ସରପଞ୍ଚ ନଥିଲି ତେଣୁ ମତେ ଆପଏଣ୍ଟମେଣ୍ଟ ଲେଟର ଦେଲେ ତ ମୁଁ ଯାଇକି ଜଏନ୍ କରିବି ତା ଫର୍ମାଲିଟି ମେଣ୍ଟେନ କରିବି ସେଇଟା ମୁଁ ରିପ୍ରେଜେଣ୍ଟେସନ ଦେଇଛି। That is pending, that not disposed of. କିନ୍ତୁ ଏବେ ହଠାତ୍ କିରି annexure 4 ଆମର ହଉଛି 13ଟା ଅଙ୍ଗନବାଡି ସେଣ୍ଟର ଅଛି ନୂଆଗଡ଼ ଗଜପତି ନୂଆଗଡ଼ 13ଟା ଅଙ୍ଗନବାଡି ସେଣ୍ଟର କିନ୍ତୁ ଏଥିରେ ସେ ବାହାର କରିଛନ୍ତି କିନ୍ତୁ what my information is there ସେଠି ଲେଖିଛନ୍ତି with reference ଏଇଟା ଏବେ ବାହାର କଲେ 9/7/24 ରେ ବାହାର କରିଛନ୍ତି with the reference subject above I am to say that the selection of 2 post Anganwadi workers under ICT project Nuagada, Gajapati, 18/7/2024. And my information there, my appointment is against Nuagada Center 5.
No, but you must come up with a clear case. Either you want to continue as Sarpanch or Anganwadi or whatever.
Once
You cannot hold both the posts.
No, then that is suppose if
ଏପଟୁ ବି ଖାଇବେ ସେପଟୁ ବି ଖାଇବେ
ହବନି
ହବନି
ହବ କେମିତି
ଆମର କୋଉଠି କହୁଛନ୍ତି ଆପଣ where is your case? Concrete case ଗୋଟେ ଦିଅନ୍ତୁ, we'll record it and we'll pass that order. So
This is my
yes, what do you say?
That was the direction in annexure 1. If my lord
that was
making a submission to that effect, that might be taken to consideration.
No. He has got also a valid point. Supposing she resigns and you don't issue an appointment order, then where will she be? Majinore basi debe ki? So whether you are willing to abide by this annexure 1, come up with a clear case.
That was in the year 2020.
She will say that she's willing to quit, and unless you issue an appointment order, and that's a valid argument.
ସେଇ ଗୋଟେ appointment letter ଦେଇଥିଲେ ମୁଁ ତ ଏଇଟା format
Next week, no, I'll taste.
Sri Srinivas Mahathi, learned counsel appearing for the petitioner, submits that his client is interested to join as Anganwadi worker. And for such purpose, she is also willing to resign for the post of Sarpanch, being currently held by her. Stop. She was called upon by annexure 1 to resign as Sarpanch. But in the absence of any engagement order being issued as regards the Anganwadi worker, stop. His client is not willing to take the risk. Stop. Learned State Council shall take instructions in this regard. Place this matter next week.
Hello, to this stay. Selection kar posting kar. There shall be no posting in Nuagada 5. କିନ୍ତୁ ସେମିତି ଆନେକ୍ସ 2 ରେ ମତେ ସିଲେକ୍ସନ କରିଛନ୍ତି କିନ୍ତୁ ମତେ ନୋ କମ୍ୟୁନିକେସନ
All right. There shall be stay operation of the order dated. Order to no eta kono.
ହଁ ଗୋଟେ
Order dated 9/7/2024 of the CDPO Nuagada. Hala till the next date.
With respect to Nuagada 5 Anganwadi Center.
With respect to Nuagada 5 Anganwadi Center.
Item number 14. Legal person. The petitioner limited grievance. Limited grievance after completion of 60 years in view of the circular issue 2009 and revised 2023. Though she was given his consent for continuation to 62 years. It is recommended by CDPO under Annex 2, 3 and 4. But still the sub-collector is not taking any decision, is pending. A petitioner is an annexure 5 series I have enclosed. Till date, he is allowed to discharge his her duty, providing the foodstuffs and other materials.
This is Anganwadi supervisor.
No, worker.
Anganwadi worker 62 years jaye continue to kari.
Yes.
Yes.
Disengagement. Is
2 years,
60
re-engagement 2 years.
But re-engagement for another 2 years.
Yes.
In terms of that resolution of 2019, subject to a condition, if the petitioner will apply for the same prior to 2 months of his retirement. So here in this case, my lord, if a lordship will come to Annex 2, the 60 years will be attained by lord by 30th March 2024.
Yes.
As it reveals from page number 19, my lord.
Yes.
The second line, my lord.
Hmm.
And my lord, the application submitted by the petitioner, my lord, in page number 17. That is on 13/3 to.
So not 2 months before. Anyway, let them consider.
Yes.
Let them consider. The petitioner's grievance is that the case of the petitioner is that she is working as Anganwadi worker in Kou jaga? Golamunda Anganwadi Center.
No, sorry. Manjari 1.
Manjari 1 Anganwadi Center. She attained the age of retirement. She attained the age of 60 years on 30/3/2024.
31.
Prior to that date, she submitted her willingness for her re-engagement as Anganwadi worker for a period of 2 years, for till 62 years. Her case appears to have been recommended by the CDPO, the sub-collector, by letter dated 2/7/2024. No, sorry, it's 31/3/2024. 22/3/2024. 31/3/2024 and 2/7/2024. It is a grievance that no action has been taken as yet on such recommendations, though the petitioner has been allowed to continue. Stop. Limited grievance of the petitioner. The writ application is disposed of, directing
4. Okay.
opposite party number 3. Sub-collector.
Sub-collector. 3 भूले sub-collector.
CDPO पर recommend करछन्ती.
Recommendation 4.
Sub-collector करे.
5 होगा सर 3 टा डबल है.
अच्छा. तुदी लिखंतु. एटा सेटा करेक्शन कर दियो करो. आगे प्रथम लिखंतु learned counsel for the petition is permitted to correct the typographical error in the cost entry in court. अब तापर लिखंतु. सेटा लिखंतु is directing the sub-collector party number 4 to take a decision with regard to the recommendation made by the CDPO regarding re-engagement of the petitioner. Within a period of 1 month from the date of.
May I submit only? My lord, the initial proposal which was sent by CDPO, as per the averment in para number 15, that has already been written by the sub-collector, my lord.
And thereafter, the fresh recommendation is 2/7/2024, which is paid.
ହେଲା ଆର ଦିଟା କାଟି ଦିଅନ୍ତୁ ହେଲା ଆର ଦିଟା କାଟି ଦିଅନ୍ତୁ ଖାଲି 2/7/2024 ଲେଖିଦେବେ ହେଲା within 1 month. Within one month from the date of production of certified copy of this order by the petitioner. Obliged.
Till then, no proceed. Otherwise, police.
Since it is submitted that the petitioner is continuing as an Anganwadi worker, she shall be allowed to continue till disposal of her representation.
Obliged.
Yes. Will be allowed to continue as such till disposal of her representation. Yes. ଛାଡ଼ି ଦିଅନ୍ତୁ ସେପଟକୁ ଯାଆନ୍ତୁ
Item 15.
Well, it is a matter, a very peculiar and serious matter. The petitioner is working as a Jogan Sahak, and he was appointed since 2015 in a Bhaleshwar GP by the collector. Then new election came, and she didn't want that this person who belongs to that village should continue Jogan Sahak. And Annexure 3, page 14, kindly see that Goshti Unayana Adhikari, Nuapada video wrote to the Sarpanch that କୌଣସି ଗ୍ରାମ ପଞ୍ଚାୟତ ସରପଞ୍ଚ ରାସନ ବିଚାରର କାର୍ଯ୍ୟକ୍ରମରେ ପ୍ରତ୍ୟକ୍ଷ ଭାବେ ଲିପ୍ତ ରହିବା ବା ହସ୍ତକ୍ଷେପ କରିପାରିବେ ନାହିଁ ସେ କେବଳ ରାସନ ବିତରଣ ପ୍ରକ୍ରିୟା ତଦାରଖ କରିପାରିବେ so he as a ଯୋଗାଣ ସଖ୍ୟା but still then she raised objection and there is a committee against him that what is that she did that any misappropriation or anything page 16 annexure 5 the report of inquiry of Bhaleshwar GP. And in conclusion, my lord, there is from the above, it is found that there is no gap in the distribution of PDS commodities. Still, the locals don't want Jay's Dol Singh Sau. My lord, this is the inquiry. Thereafter, he was allowed to work there, but the Sarpanch didn't allow him to work. Then, my lord, kindly see that Sarpanch later.
No, so you were transferred to another Beltukuri Gram Panchayat.
Then when I was about to join there, they recalled me. And collector said, no, Jogan Sahak cannot be transferred course order, that they have recalled that transfer order. Again, I have come back, my lord. My lord, kindly see Annexure 10, page 24. The Sarpanch's audacity to write such a letter to Block Development Officer regarding engagement of temporary pure, Jogan Sahak, SM for smooth management of GP work. With reference to your office letter number such and such, there is circular notification that I apprise before you good sir, kindly go through section 100 OT3G. If any authority please, then proposal submitted to government for amendment of section 123. He will write government to amend the amendment Sarpanch.
Yes, taken the help of a local lawyer. ସେ ପାଖାପାଖି ଯିଏ ପ୍ରାକ୍ଟିସ କରୁଥିବା ମଫସଲ କୋର୍ଟ ଓକିଲ କାହାକୁ ଲେଖି ଦେଇଛନ୍ତି
BJD president. Page 25 annexure 11, my lord, kindly see. That's another. Regarding handing over charges to PDS, Sri Dolo Singh Sau, ex-Jogan Sahak, Sarpanch is writing, there will be a law and order problem if that will not be done. My lord, kindly see. I am to intimate that people of Bhaleshwar GP are not desiring to receive from ex-JS. He has terminated the service. Ex-JS.
I am willing to consider your application, but her prayer, her first part of your prayer, how is it maintainable to take action against Sarpanch for writing a letter? Is the High Court is the authority or what?
I am saying the opposite party number one government. My lord, I am not saying that this court that
True.
he is violating the government's order. He is not my appointing authority. And Gram Panchayat.
When you take notice?
Yes.
And my salary, everything is stopped, my lord.
Yes, we'll pass an order. Learned AG accepts notice for opposite party numbers 1 to 5. Issue notice to opposite party number 5. Take notice on Sarpanch.
My lord.
Separately. Issue notice on opposite. Who is this opposite party number 5? He is a private party.
I have made him by name. Because I always qualified that.
All right. See, issue notice for opposite party numbers 1 to 4.
Yes.
Issue notice to opposite party number 5 and 6 by registered post with AD, returnable within 4 weeks. The requisites be filed within 3 working days. Does this matter?
9 September. 9 September.
9 September. Stop. In the meantime, the opposite party number 6 is directed to release the to disburse the current salary of the petitioner. That's all. Current salary of the petitioner.
That upon number 4 will civil supply official will release. Not the servant.
Well, if OP number 4 will release, my lord,
Yes.
then I will take the instruction. This may be taken up next week.
If not already released, we'll say that. If not already,
Yes, yes, yes.
public party number 4 is directed. Huh? To directly disburse the current salary of the petitioner, if not already disbursed.
Right.
Yes.
Item number 16.
In 16, your lordship by order dated 19/6/2024 had put it before the director higher education to inquire because it involves factual aspects. I will have to take instruction as to what has happened so far. He was to notice and to hear.
You received notice? Notice, received notice?
So far as my instruction is concerned, my client has not
Yes, Mr. Raiguru?
Has not.
This director,
नहीं मत notice.
19/6 ରୁ order ଦେଲାଣି ଆସି ଆଜ୍ଞା ଅଗଷ୍ଟ ମାସ ହେଲାଣି. Will not comply with that order.
Sure.
You take instruction, I am calling it tomorrow. List this matter tomorrow. Learned State Council shall take instructions as to if the directions of this court have been complied with. 19/6/2024 have been complied with or not. Yes.
Item 17.
Day after tomorrow, Karo, day after tomorrow. Day after tomorrow.
Lordship interim order to continue.
And interim order.
Item 17.
Please ask him telephonically.
Sure.
Otherwise, he'll appear and he'll
Sure.
file an affidavit.
Lord, this
I think there was no director probably.
Somebody was recently,
In the rank of
He used to delegate the authority to either a joint director or anybody.
yes,
So that order has to be passed by the director.
not below the rank, your
Not below the rank of the joint director, that is what I've said. The order could have been passed by whoever is in charge.
yes.
Yes. Item 17.
So this is an interlocutory application during pendency of the second appeal.
No, you're on the wrong list. Yes, Mr. Tripathi,
Supplementary.
Asandu. This is not your list. That is a weekly list.
Seth, I was confused. No,
No, you are confusing everybody.
no.
You should have appeared. By sitting there, I am confused. Why are you sitting there? So I was confused.
I'm sorry. My lord, may kindly see on the last occasion, directed me.
You have perused the case records?
Yes, ma'am. My lord, one thing. Your lordship, I want
Oh,
to.
that Maulana
Yes,
My lord. Maulavi.
Maulavi.
One thing I want to draw 21. Recently, your lordship reacted in a case, what is religion? Simti, तुम Shia Muslim, हमें Sunni, will not allow you. Same thing, ताको out करी रखिले. Government letters are there. Your lordship may kindly come to page 21. Page 21, my lord. Annex 8, page 21.
Yes, I remember. Exactly.
Paragraph 3. But the principal in charge government junior senior madrasa so and so could not able for duty in the junior so and so in Jaipur due to strong present at a protest Muslim public. Muhammad Mauli, because Muhammad Motiullah, this present petitioner belongs to Sunni Muslim community and they are all of their IC.
Wahhabi election.
To Sunni black age.
नहीं से बिल्कुल लिखा जो OWHA से WAHAB है
Yes.
Wahhabi.
For this reason, and your lordship may kindly see, first from the beginning, my lord, I am.
He has only stated the facts. That is कारण पे समझने तक वो allow करना था.
Page 14. Annexure 1. It is clear from the beginning, my lord. Page 15, this is a letter dated 20th/9/96. After completion of my training during 93, I would have joined. They did not allow. So the letter, your lordship may kindly see Annexure 1. This is the letter from the deputy director to director. This is their my government letter, my lord. I am directed to say that on perusal of the case reveals that natural justice has been Mohammad Motiullah. Deputy Director is writing this letter to Director, ex-head Maulavi Madrasa Sukinda, since he was one of the Maulavi in the institution approved by the Director and was sent for city Urdu training under a resolution of the managing committee dated 13/9/91, it would have been fair to accept him in the same institution after completion of his training. The appointment of so and so reveals that against the appointment I am not with that. So they have decided, I am the trained Maulavi, I have come, you should allow me to join. Then page, your lordship may kindly come. Last 4 lines I am reading. Further, the inspector of school Jajpur will make payment in favor of Muhammad Motiullah, Maulavi teacher of the madrasa in question, from the date of his joining in the institution after completion of city training. Mu complete karichi. Everything they know. Then my lord may kindly come to annexure 3, next page. My lord, all the annexures in my, this is not my case, only the communication of government, deputy director to director, inspector to director.
On the last page, Mr. Tripathi, you have already placed these things.
My lord.
So I think.
So ultimately, when High Court, this Honorable Court Division Bench directed you allow him within 7 days, the next day, during 2010, I was allowed at Dhamnagar. I am continuing there since then.
So your prayer is for salary, your salary from that.
Those things reveal from the letter of government only.
Just wrong. Prima facie, the principle of no work, no pay will not apply. Because he has been running from pillar to post, from this institution to another institution. And because the concerned institution does not allow him to join, he could not join. He is ready to work, but you are not giving him work. So what would be the principle in such a situation?
My lord, the last occasion, my lord, the metro was actually adjourned to today to peruse the 2 records, my lord,
Yes.
previously filed. So the petitioner had previously appeared before this honorable court in the year 2001. In OJC number, that OJC number is there, my lord.
Yes.
The record is also there. Wherein his prayer was to allow him to release the salary with effect from 2000. Here the prayer is from 1993 to 2010. There his prayer was from 2000.
Yeah, I think that part can be curtailed.
Yes.
From wherever he is entitled to, that can be.
Yes.
Now, coming to that second point. Now, in that case, there was a direction that inspectors is to take a decision in this regard and to the authority to take action against that management committee in case he will not allow the petitioner to accept his joining report. So, a counter case was filed by the managing committee in the year 2003, where there is another interim protection. So, in that case, my lord, in the second case, the state has already filed a counter. And in that case, my lord, one para, I think, my lord, that is para number 12 or 9, my lord. There, even though the petitioner was offered with appointment, engagement, but he didn't join there. That is also one of the appointment, my lord, of the state. So, taking some plea or other, my lord, he didn't join there. Thereafter, both the cases were disposed of on the ground, on the basis of the point, my lord, that a director has issued an order that the petitioner will be suitably adjusted in another place, that is at Dhamnagar. So, taking note of that particular fact that director has already decided, Honorable Court disposed of the case, my lord, that particular order of the director, and in terms of that particular order, my lord, the petitioner joined.
Well, this is the matter. We'll see. I will consider all the 3 writ applications. I will.
And my lord,
Night, how the
hearing concluded.
Regularity house entire period ta regularity house.
Seita hi pare.
As your lordship pleases.
Act 18.
Hearing concluded, judgment is up. What can you do? Particular file the written note of submission. You're going to week a week or week time. Yes.
My lord, on the previous occasion, party to take instruction in response to the paragraph 4 in the rejoinder affidavit, which reflected that some other persons who were similarly placed, their services were regularized
And why not the petitioner?
We would like to know the response of the opposite party institute in this regard. Who's appearing for the opposite? Yes, Mr. Marana.
My friend is here.
I was filing a reply to the region that asked for that.
No, I think an affidavit was directed to be filed, whatever. Rejoinder of upon file kori. Affidavit be filed. Yes. You are filing it today? Then serve a copy?
Just
Have you answered the amendments in paragraph 4?
yes, madam.
There was a specific direction. This affidavit is being filed pursuant to that direction.
Yes, madam.
In pursuant to lawsuit direction, yes, the government has filed an affidavit, my lord, with regards adducing some documents, additional documents, my lord. And though I have also gone through the same, I just want one more chance till next week at least. Because
As requested by counsel for the petitioner, let this matter next week. Hold it.
next week, Monday. Much.
I don't know, 20.
No instruction dispose of.
Item 21.
One minus I remember taken up 10 days after.
2011.
11 matter and I was,
Readings was otherwise ready. I have not completed.
I was removed from the service matter 2011, challenging the.
That is there.
Ella Mr. Pandit, that's the time option.
Next week or next Monday.
The next Monday तक next Monday
Next Monday.
14 तारीख को रख ले.
देखो ना। As requested by Sri Dayananda Mahapatra, list this matter on 14th August.
22.
22, my lord, I may be permitted on behalf of Mr. Somendra Mahato who has left. I have to file the amendment petition because the husband has been substituted, but I have prepared not typed. Let it be taken 1 week after or next week. I will be filed in that time. My lord senior is there.
Correct. As requested by learned counsel for the petitioner, list this matter next week. Amendment application, if any, be filed in the meantime.
Obliged.
Mr. Kora, you are the CGC?
Yes.
You are CGC, Mr. Kora?
No, I am special.
May I please, your lordship? Item 23. But small matter, that is last occasion your lordship had. This petitioner was appointed in the Utkal University as junior assistant on consolidated wage basis. But when his services are not regularized, then he approached this honorable court.
You filed your consolidated application?
My lord, that is, and also copy has been given, and your last occasion, your lordship has said the matter is very simple because in other employees, they have already extended the pensionary benefit. This fellow retired in the now 9 years has already been passed. He is not getting any pension or pensionary benefit. Okay. And your lordship, I have given one affidavit, just your lordship, just have a glance to that affidavit. That is also in the record. And this is.
My lord, see if I am allowed to interrupt, your lordship had allowed me time till 5th.
Use the mic, Mr. Patnaik.
Your lordship had allowed me time to get instruction by 5th, but I am constrained. I have only got a telephonic information which I am not able to, I may not be able to convince your lordship. So your lordship, I kindly grant me time till next Monday. I will file a written submission.
As requested by Sri T.P. Patnaik, learned counsel for the university, let this matter next week.
E.N. Patnaik.
Sorry. I always give.
Taranando.
Which is.
Mr. Mahathi, it's not as if I am knowing him for the first time.
No, my lord, sorry.
I am obliged.
Memory.
Item 24.
TP note, T.N. Patnaik.
Item number 24, before my learned senior starts, have instructions appear on behalf of one of the opposite party. Earlier, the brief was with Honorable Justice Sri Mahapatra, A.K. Mahapatra. It needs some time to obtain instruction in the matter whether she wants to still pursue the matter.
If my lord wants to take instruction, he also may take instruction on the matter. In the meantime, and I have got the information on RTI Act that she has already been engaged somewhere, the private
Opposite party.
Yes.
So she may not be standing in your way.
Yes, that is.
Take instruction.
And apart from that, my lord, in the meantime, that Anganwadi center has been bifurcated since long and she is coming under that newly created. So that instruction you may take. I am also giving the.
Sri Lanka Learned Counsel for the petitioner submits on instructions that the private opposite party number.
That would be opposite part number 5.
Private opposite party number 5 has been engaged somewhere else, and that the Anganwadi center in question has been bifurcated. Has been bifurcated. The private opposite party is a resident. No, it's not. Learned counsel for the opposite party wants to would take instructions and shall take instructions in this matter. Place this matter on
2nd September. March.
2nd September. Out of earlier court.
Since 2014, she is out of.
22nd August.
22nd August.
Lawrence senior may also take instruction on that regarding bifurcation. So that I think.
Learned State Council shall also apprise the court regarding the bifurcation of the Anganwadi.
The notice I have already filed by way of an affidavit. That is there in the record.
No, let it be there on that day. We'll find out.
Yes. Now, in the meantime, we may take instructions.
Yes.
So that
No, that is what I have said.
25.
It may plead your words. The petitioner has challenged the order passed by the Additional District Magistrate Sonpur on 4/11/2015 without.
My lord, before my learned senior continues, my lord, I'm appearing for opposite party number 4. My lord, I'm filing a counter affidavit to the rejoinder affidavit.
Private opposite.
Yes, my lord. My lord, I will wait in case your lordship requires, my lord, I'll put that on record. But if my learned senior wishes to continue, my lord, I'm ready.
No, but that he can be ready because you are filing something. You
Yes,
have a copy of it. Mr. Mahanti.
I have not.
ତାହେଲେ କେମିତି ହବ ଏଇଖିନା କପିଟା ଆଗୁତରା ଦେବେ ଲାଷ୍ଟ ସିଟ୍ ପଡିଲା ବେଳକୁ ଆପଣ କପିଟା
My
ଦେବେ
lord, actually କଣ ହେଲା କି ମାନେ 2019 ଆଗରୁ ଆସିଥିଲା ତ in the mean time my lord ଆଉ
ଆପଣ କୋର୍ଟ କେତେ ସମୟ ଠିଆ ହେଲେଣି ତମକୁ ତ କପି ଦେଲେନି
my lord ସେଟା ଦେଇଥିଲେ ବି ସେମ୍ ହିଁ ହେଇଥାନ୍ତା ଆଜ୍ଞା
ସିଧା ଆସିକି ଏଠି ପହଞ୍ଚି ଯାଇନି ସେପଟୁ ଆସିଛି ଏପଟୁ
ସାଇନ୍ କରିଦେବ
ଠିକ ସମୟରେ ଲାଷ୍ଟ ମୋମେଣ୍ଟରେ ଦେବେ
my lord, I did not want to put it on record but there is certain things that I wanted to
whatever. On merits I am not saying anything.
ନାଇଁ
2015 matter you should show some promptitude.
my lord ଆମର ମେମୋରେ ଆସିଛି ଆଜ୍ଞା ଆମେ ମେମୋ ଦେଇଛୁ
ହଁ ହେଲା ଆପଣ ମେମୋ ଦେଇଥିଲେ ଟାଇମ ନେବେ ବୋଲି ଆଉ କଣ
ନାଇଁ ନାଇଁ ଆଜ୍ଞା
ସେ ତ କଣ yes Mr. Mahanti you are filing an affidavit.
My lord, I'm filing a counter affidavit. My lord, just one thing, my lord.
Counter affidavit there.
Original counter affidavit or
Original counter after 9 years.
Yes. My lord,
the land counsel for the opposite party number 4 files a counter affidavit in court after serving copy on Sri Mahanti, counsel for the petitioner, who wants some time to go through the same. Is this matter next week?
Next week I will not be available and I will contact the client, my lord, finally.
All right. Then
3 weeks time, my lord.
2 weeks.
2nd September.
We'll take it up on 2nd September.
Interim order may continue, my lord.
2nd September, interim order.
my lord, if my lord, there is a prayer, my lord, it's a very difficult thing. Why, my lord? Because there are certain things that I've shown in my affidavit that the petitioner has committed fraud by taking down signatures of persons who have not done that. In the same, my lord, that is also the case of that is also my case, my lord, that I am saying. So the petitioner will obviously say that I am. My lord, may kindly send this to the persons who have sworn in those letters if they're true or not, my lord. My lord, may call for an inquiry.
No, let us first hear.
As you
have to short date karo.
My lord, 90 ବର୍ଷର ଲୋକମାନେ
20th August.
20th August, Mr. Mahanti? Yes, 20th August.
As your lordship, please.
Item 26.
Item 26 seeks for Passover.
All right, pass over.
27.
शिक्षा चाहेगा ठीक से डायरेक्शन टू creating as the recruiting since the date of advertisement and for other benefits.
Yes, please, you have to begin again.
Petition is continuing as शिक्षा चाहेगा.
Yes.
And शिक्षा direction.
Oh, he already is continuing. He's continuing.
Continuing since 2013 mila.
So what is your grievance here?
Grievance is similar footing candidates their service already have regularized and I have deprived my legitimate right.
So what is the case? Let us see.
2011, 26/1/2011, advertisement issued for filling of Shikha Sahayaka. Thereafter, the petitioner having the qualification of Shikha Shastri, he was applied in the district of Noyagada, and his application was rejected on the ground that Shikha Shastri is not equivalent to the bid. Thereafter, the petitioner challenged the said impugn order, and a bunch of cases already filed, and one common judgment has been delivered since 25/8/2011. And thereafter, in that judgment, this honorable elected to give the engagement to the petitioner along with all petitioners as the Shikha Shastri is equivalent with the bid. Thereafter, 2 years delayed for issuing the engagement order. 17/8/2013, engagement order was issued, and I have joined on 23/8/2013. But the authority has not considered to treat me as the recruit in pursuant to shared advertisement.
Yes.
That is the fact.
Yes.
In paragraph 8 of the counter affidavit, the hard copy of the counter affidavit may kindly have.
Yes. It is.
It has been stated that due to non-compliance of the order dated 29/3/2012, the petitioner again filed CONTC contempt against non-compliance, and ultimately, in compliance with the order, the DPC, Noyagad.
So the collector has rejected his claim for antedating his date of appointment.
Yes.
That will always be on notional basis. If at all he succeeds, it will be on notional. The purpose of adding 2 more years to his claim, isn't it?
Yes.
So what is the order of the collector?
Of the collector.
Just said that with the direction of
Annexure 8 below.
13/2/2015. Annexure 8. Yes, let us see. This is the order impugned, isn't it? कौन इधर पढ़ी हो नहीं तो कौन सी? What is this order? I don't understand.
Rejected on the ground that petitioner had claimed to treat him as the recruit 2011 with all consequential benefits since 2011.
Where are you reading from?
Page 41.
Of the petition.
ये annexure क्या थे?
Annexure 8 मिला. The previous petition जो था फाइल था.
Something else is showing. Huh? Annexure 8 आगुड़ कौन खोल दिया? देख ले? शिवदत्त Tripathi. Annexure 8 is to the rejoinder.
No, Miller, that is the annexure of the WPC, dispute of case.
6479 of 2015. Oh, in that case, annexure 8.
Miller.
What happened to that? So you challenged it again.
Challenge. This honorable court rejected on the ground that he has not continued his duty.
Sir, what happened? What happened to this writ application? The writ application कौन वाला?
Person was rejected.
Writ application was dismissed.
Milan.
So now?
Now I am thereafter another similar candidates from the state district. Her grievance was considered and treated her as the recruit of 2011 and consider for the other benefits her date of joining is considered.
Where is that? Where have you said that? In your writ application.
Miller. Annexer 5 Miller.
Sujatharani Ratha.
Miller.
How this was done? What is the answer to this? Where have you stated about it in your writ application?
It's a block resource teacher.
You have to read from paragraph 8. How have you answered? Let us see. You haven't given a paraphrase. No, this is paraphrase.
No averment is in the account.
Oh, you were working as block resource teacher. It is covered by my judgment.
Say, Justice Mruganga Shekhar Shamkar जो order टा इठी थिले. That was the previous case in this.
So in 2011 you were block resource teacher.
2012 I had working as a BRT as they have the opposite party has delayed intentionally delayed to issue the engagement order. No engagement order पाया ପରେ ମୁଁ continue करनी ମୁଁ resignation ଦେଇଥିଲି.
କାଇଁ ସେ ସବୁ କଥା ଗୁଡା କହିଲେ ହବନି କାଇଁ where is the representation, where is your resignation, where is the order accepting that resignation, କାଇଁ ଏ ସବୁ what file 2015 ର matter କେବେ କର 2020
It filed in the year 2015.
Yes.
Which was disposed of on 6/5/2022.
Will it not act as a judicata?
That is what manner, and on the last occasion, the Lordship had asked for that particular
record
for reference.
Yes.
Because we had filed at the order of the Honorable Court at page note 54 annexes G/5.
Yes. There also the prayer was
the same prayer, my lord, the first prayer, my lord. Lord, the both prayers are different, my lord. In the previous repeats, the prayer was consider as treat him as a recruit to 2011 with all other consequential benefits. In this repeats, my grievance is for my appointee consider from the date of my advertisement, but other benefits consider my date of my engagement. ମୁଁ ସେ ପର୍ଯ୍ୟନ୍ତ କିଛି ମାଗୁନି ମାନେ କୌଣସି ଫାଇନାନ୍ସିଆଲ ବେନିଫିଟ ଖୋଜୁନି
same needs the appointee of Shikha Sahib under your category in advertisement pursuant to advertisement dated 23/1/2011 at par with petitioner of WPC number ete and his batchment.
In the terms and condition of the
pending ରଖିଲେ ହବ କଣ?
Direction.
Pending ରଖିଲେ ହବ। All right, hearing concluded, judgment is out.
Item 28.
Ma'am, please. Petitioner is a physician having made a qualification, succeeded Lordship in the OTT for engagement of Shikha Sahib. Lordship, for that purpose.
Yes.
For that purpose, Lordship, kindly come to page 24.
What is this?
Lordships, that is Annexure 4, page 24. Lordship got it? Odisha Primary Education Program Authority, OPEPA School and Mass Education Department, Government of Odisha. My lord got it? We'll come to turn the next page at serial number 191.
Yes.
Lordship got it?
Yes.
Serial 191. My name appears. And in the last column, Lordships, kindly on the end, kindly see HI, handicap.
Hearing impaired.
Hearing impaired. So, Lordship, it is eligibility under trend. Right? Thereafter, they did not permit me to join. Then they took me under reserve on trend candidate. Lordship, that starts from page 26, Annexure 5.
Yes.
A relevant page, Lordship, is 28. Lordship, last line.
Yeah.
I filed application before them. I went to this honorable court. Honorable court rejected my claim. Then I filed writ appeal. Writ appeal, Lordships, kindly see page 21 and 29, Lordships. Operative person is 31.
Yes.
4/10/2016. One post shall be kept vacant listing. Thereafter, Lordship, it was kept vacant. Since in the last hearing on page 34, I took opportunity to file a representation before them for redressal my grievance, Lordship. Page 34, which was order passed by this honorable court. Now one post is kept vacant for me. Thereafter, pursuant to that, Lordships, I filed an application for consideration my application. That is page 7. Till now, they did not reject my application. I filed this writ petition stating that since I throughout my career is first class, I was duly selected and one post was kept vacant for me and I was hearing impaired, my case may be considered. They rejected by saying that since you are a BEd qualified, you cannot be treated as a CET qualified. It's kindly come their notification. Notification, Lordships, it's page 38.
Where have they said that? Your representation is still pending.
No, representation they have disposed of.
Where is that order?
Against that order,
where is the disposal of your representation? By which order?
this is a counter, they have stated it. In the counter, they brought to their notice.
Page 21 of the counter.
21, page 21 of the counter. When notice went to them, have already rejected your claim. Now what they are saying, same thing has they have come, that has come with a notification that they have taken into consideration.
What is this? Let us see.
May I read, Lordship?
Yes.
To become convenient for my lord.
Yes.
But quickly I am reading, Lordships. After some arguments.
No, the crux of the grievance.
Quickly I am reading. The filed by the applicant on 25th to 2017 is that she was an applicant for the post of Shikha in Balasore district for the year 2014 and 15. She is a trained graduate of OTT 1 qualified, applied for the post meant for city category. Her case was not considered, though Honorable High Court Orissa has passed an order in the DT appeal so and so arising in her favor. On perusal in her district during the year 2014-15 through online was found placed in serial number 191, she is admitted in the list of eligible applicants. Consequent upon verification of application form of the applicant, it is revealed that she is a graduate and obtained BD degree from Dr. C.V. Raman University, Kargi Road, Kota, Bilaspur, Chhattisgarh, and also passed OTT in paper 1 during the year 2013. The additional secretary to Government and School and Mass Education Department by letter number 20383 of the SME dated 29/8/2013 has clarified that the candidates did not apply under BD category post, though the candidate has basic qualification. Similarly, the candidate passed in OTT cannot also apply in city category of post. In the present case, though the applicant has qualified OTT 1, she does not have city qualification for post meant for city category. Hence, she had been treated as untrained candidate. On the other hand, as she had not qualified OT2, she could not be considered under BD category of post on strength of her BD training. The applicant had challenged the same on the writ petition which is extracted. This is the first order, Lordship. On considering the facts, above facts, it is held that the case of the petitioner rejected being devoid of merits. Now, Lordship, I'm
Just. Yes. So you admittedly you do not have city qualification.
No. I do not have city qualification.
So
I am BD qualification. Lordship, kindly come to page 40.
40 of?
Their notification, Lordships, 39.
Of the counter?
My writ petition. This is what Lordship argued before the Honorable Division Bench. Division Bench did consider it because thereafter was pleased to kept one post vacant. Thereafter, the Division Bench, when I argued, I seek the liberty to make an application on fresh, Lordships, which they did not reject. Pursuant to my writ petition note saying that you are not eligible. Now, my humble submission, Lordship, kindly come to page 39 in their notification. A notification started from page 38. Relevant para is page 39, graduation. Lordship, got it? Graduation with at least 50 marks and Bachelor of BEd on the condition that who has acquired the qualification of Bachelor of Education from any NCT recognized institution shall be considered for appointment as a teacher in class 1 to 4. The person so appointment as a teacher shall mandatorily undergo 6-month bridge course in elementary education recognized within 2 years of such appointment. What is the contention today? They say that since you did not have qualification, your case was rejected. Now, to this effect, they have come with a notification 2019, Lordship. This aspect they are considered and they are taking student. This aspect I could not file in the region of this is a notification flashed on the net, Lordship. If your Lordship required, I will get it by tomorrow. This is discriminatory, Lordship. Now they are saying, rejecting that you did not come with the claim that you are hearing impaired. Lordship, now in their counter, Lordship, see, and now it is in their list itself says that I am hearing impaired.
This is for Orissa teacher eligibility test, which is OTET. Correct. So it refers to all those persons, the eligibility for appearing in that test.
Yes.
It does not say anything with
For
regard
that
to.
purpose, is being treated as.
I have not completed. I have not completed. So your case is there. Your case has been rejected on the ground that you do not. You are not eligible to be appointed as Sikha Sahib, as you do not possess the city qualification.
City qualification. Since you have possessed the BD.
So how does this notification help you?
Lordship, this notification helped me to the extent that, Lordship, I am admittedly.
They have excluded OTET qualification as one of the eligible conditions. Only because you have OTET qualification will not make you eligible for that post. That is what they say.
Precisely wrong. I am not on the footing that OTET qualification, Lordship, comes next, Lordship. First, I must be eligible, Lordship. The notification says BD 50%. Now, pursuant to that, they consider it. It is their list. They admitted my position. I have duly pressed every document. They put me in the trained graduate. Now, this backed up, Lordship. Again, I am reading this. Again, this page 39 that give me rider in the last graduation with at least, Lordship, holding page 39.
Yes.
Graduation with at least 50 marks and Bachelor of Education on the condition that who has acquired the qualification Bachelor so and so.
Your application. Yes, just a moment.
As a teacher, mandatory undergo a 6
course. Your application was for Sikha Sahayak under city category. They have a required criteria.
Lordship.
That which excludes OTET. It says that even if your clarification was issued, as I find on the record, that a person having OTET qualification but no city qualification will not be eligible. That is, you attack that point.
That is not there. That notification.
Just a moment.
That
what is your
kindly see.
Reply is.
That is as page 8.
Just a moment. Why are you so worried? Just a moment.
Engagement process of 14 and 15 has already been completed.
No, that is we are not on that one. You have rejected his claim on the ground that he does not possess city qualification.
Then
though he possesses OTET qualification. Some clarification appears to have been issued by. What is his competence that we have to see?
Giving about further qualifications.
No. What is his competence to issue such a clarification that we have to see? The government can issue. Government has clarified that candidates passed in OTET 1 cannot apply under BD category. And similarly, candidates passed in OTET 2 cannot also apply under city category of posts.
Yes.
So this is the clarification issued by the government, for which your claim was rejected.
Now, this aspect they have considered in 2021. That's notification.
Where is that?
But that notification flashed on the net that I need to bring it. This pursuant to this 13, they come with a revised clarification that BD, qualified BD shall be also eligible for.
All right. Learned counsel for the petitioner submits that. The government has issued a revised guidelines superseding the earlier guidelines. Yes, so guideline of revised clarification superseding the earlier clarification issued by it 29/8/2013, as per which the candidates with OTET 1 and 2 qualifications cannot apply under city category of posts. According to learned counsel for the petitioner, the recent clarification allows persons with OTET qualification to apply under city category of posts. Is that so? Learned counsel for the petitioner further seeks time to produce the copy of the clarification, which is said to be available in the net.
Apart from the merits, this is added point.
Sorry. Let's this matter next week. Next week,
13, Lordship, I am not available.
Next week it will come on 12th.
On 12th, 13, I am not available.
So 12th matter is 13th available.
Bar.
Bar is
Item 29.
29, my lords, that disengagement of the GRS on the ground of poor performance. In earlier writ petition, my to consider the threefold arguments of the petitioner.
So they have not considered.
My lord, I was directed to take instruction in this regard. My lord, I have received that instruction, but I found from the instruction, my lord, that the 3 points which the lordship had specifically indicated in the order, these are actually not clearly discussed in that order, my lord. And that order was actually passed by opposite part number 1. So the appellant authority would have been, my lord, the director.
So what to do now?
No, my lords directed to OP number 1.
That is why, my lord, the order was complied by the opposite part number.
Because OP number 1 has issued a circular that poor performance cannot be a ground for disengagement. That is at page, my lords, page 40. Page 40. My lords, a circular has been issued by the Secretary PR Department that poor performance cannot be a ground.
Page 40.
My lords. Annexion 9, page 40.
This is just an observation that poor performance cannot ordinarily be taken as a ground for disengagement of a person.
My lords, in that case, a GPTA who was disengaged on the ground of poor performance
was
has been
directed to be
re-engaged. Thereafter, my lords, at Annexure 12, page 52, my lords, special director, appellate jurisdiction, my lords, re-engaged one of the GRS who has been disengaged on the poor performance.
So shall we direct him to prefer an appeal?
My lord, may
My lord, special director,
Director Special Projects.
my lord.
All right.
and he is also a party in this case.
The petitioner had earlier approached this court in WPC number 13958 of 2020, which was disposed of by order dated 29/2022, directing the Secretary of Administrative Department to consider the representation of the petitioner. Stop. In paragraph 5 of the order, paragraph 5 of said order, this court specifically noted the threefold argument made by the counsel for the petitioner. Stop. It is the petitioner's grievance that while considering the representation, the secretary has specifically considered the 3 grounds raised by him. Stop. This court would have ordinarily remitted the matter. Such being the case, this court would have ordinarily remitted the matter to the collector, to the secretary for disposal afresh. But then, as per the comprehensive guidelines
Dated 6/4/2018.
of the government issued on 6/4/2018,
my lord.
18, this court finds that alternative remedy of appeal, the remedy of appeal has been provided in case of disengagement of Gram Rozgar Sevaks. So, Gram Rozgar Sevaks to the Director Special Projects. In such view of the matter, the writ application is disposed of, granting liberty to the petitioner to prefer an appeal before the directors within 10 days from today. Stop. If such appeal is preferred within the stipulated period, the same shall be admitted and considered in accordance with law after granting proper opportunity of hearing to the petitioner. That's all. The appeal shall be disposed of within 4 weeks from the date of its filing.
without being influenced by the opposite party number one.
It goes with the appellate authority shall not be influenced by the order dated.
3/1/2023 on the stroke. Sorry, 3/1/23 is the rejection order.
My lord, sir, that order may be set aside.
Yes, 3/1
3/1/23 order may be set aside.
Where is that?
My lord,
Annex
Annex
one.
one.
Say
Say
no,
no.
14.
Without being influenced by the order dated 3/1/2023 passed by
Opposite party.
the opposite party number 1, comma, which is hereby set aside. Without harming to Bhubaneswar. Somebody is appearing for the opposite party? Yes, ma'am. Not here? Not present? All right. Sri Raut, learned counsel for the petitioner, is present. None appears for the opposite party. Place this matter tomorrow.
Item 31. Interim order is there.
Tomorrow, so actually tomorrow, just to grant him one opportunity. I don't
Interim order is one.
interim order to continue.
Item 31. Yes.
Wait, my lord. Lordship, I mean this man. I'm appearing one of the petitioner, wife petitioner in one case and opposite party in another case, Lordship. Mediation report is there, but the further mediation is adjourned to Lordship 16th of August, Lordship.
16th of August.
It is stated at the bar that the next date of the mediation proceeding is fixed to 16th August. Is this matter on
22nd August.
22nd August? Order to continue.
Yes. Grateful, my
Item 32.
In this case, your lordship pleases to the case, put the case in the mediation center. The case was posted today, your lordship.
Today,
My lord.
it is stated that the mediation proceeding is posted to today, and so is this matter next week.
Grateful, Lord.
Item 33.
33 I pray for a passover.
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 All right, Passover.
Item 34.
33, my lord. TRP. I am the petitioner, my lord. Oh, weekly list was there.
Okay, okay. You are for the petitioner.
Yes, my lord.
You are for the opposite party.
There
What happened?
There is possibility of reunion, my lord, between both the parties. Mediations.
It is.
Yes, my.
In course of hearing, the counsel for the parties submit that there is possibility of amicable settlement of the dispute between the parties, for which the matter may be referred to mediation.
I am continue.
Take order.
30th September.
30th September. It will come on 30th September. The usual order which is being passed for mediation, that order will be passed. Okay.
Item 34.
I am for the wife. Last order, your lordship.
Last order was present status regarding service of notice. Okay. I think nothing has come. So we'll remind the court below. Submit the status regarding service of notice on the opposite party. Yeah. This matter will take it up next week.
He is appearing in the court below.
That is why I have directed the court below to serve notice. So that
I think
probably
today is-
no, probably this order was not complied with in time. Otherwise, the court below, why will the court below ignore?
Today is in the lower court.
So we'll take it up next week then. This order will be communicated to the court below by email forthwith. Let's this matter next week.
Interim order.
Interim order to continue.
Well, I'm for the wife. Wife seeks a transfer from
Who's for the
the
opposite party? Anybody appearing? The name is there?
Yes, madam.
Ritu Ranjan Chotray. I'll grant one opportunity. If he doesn't appear, we'll dispose of. Tomorrow. Sri AP Post, learned counsel for the petitioner is present. None appears for the opposite party. Let's this matter tomorrow. One opportunity will.
Yes, yes.
If it doesn't appear, it doesn't appear.
Madam.
Yes, item 36.
Tomorrow in supplementary it will come. Madam.
It will come in this.
Item 6. I am for the opposite.
Yes.
And my lord, paid is for petition.
36, my lord,
In
I'm
this
for the
case,
petitioner.
And in this case, my lord, during pendency of this case, the case has been expired, disposed of. And I have filed one IA 20 of 24 for setting aside of the award.
That is pending.
That's pending, my lord. That's why I'm praying for time so that if that's
I will grant you 2 weeks time. Or
yes,
beyond
my
that,
lord. Yes, my lord.
My lord is taking time. The instruction has not been removed. The case has been posted to 23(8) for removal of defects. Whatever the position may be. The thing is that my learned friend has sought for the variation of the order is for transfer of the case from one court to another court. That is MAT suit number 32 of 2023. Fact remains, my lord. The case has been, judgment has been passed, decree also has been passed. IA, can the Judge Family Court entertain at that stage IA?
no, if it is a application under order 9,
I don't know what petition they have filed.
if it is an expiry decree, expiry decree can always be set aside or it can be challenged. If it is a matter of challenge, then this becomes infructuous.
Exactly.
But if it is a question of 913 application being filed and it is pending, so this court may wait for two more weeks.
28, the case is posted for 23(8). The lordship may posted after that. If he will take any steps or
I'll pass that order. I'll pass that order. In course of hearing, it is stated at the bar that the case sought to be transferred has meantime been disposed of by passing a ex parte decree. So, it is submitted by learned counsel for the petitioner that an application to set aside the ex parte decree has been filed, which is pending. Since the ex parte, since the case has already been disposed of by way of an ex parte decree, this court is willing to grant 3 weeks time to the petitioner in view of the fact that an application for setting aside the ex parte decree is presently pending. List this matter
2nd September.
On 2nd September. Stop. It is made clear that no further time shall be granted.
Judgment dated 4
why will
2020.
No, let us not get into the details.
Decree 25/424.
Item 37.
Transfer from Sambalpur to Ralph.
What happened? Notice was issued.
Notice issued last time. Your lordship, his father was the chance was. Father was received the notice for that chance was given, and in 15th July the case was posted at Sambalpur. Under that we have also filed.
Allowed to discuss. Allowed. Allowed.
Item 38.
May I please, your lordship? I am for
the why
just. Yes, sir. Your item is 39. 38. You are for the petitioner, Mr. Rai?
Yes.
I am for the my lord.
Yes. So you are the opposite party.
My lord.
You are the wife?
Yes.
So any chance of mediation?
No, your lordship.
No, my lord. No, my lord.
You want it to be transferred from which court to which court?
My lord.
From Bhubaneswar to Khordha.
Bhubaneswar to Khordha.
Your lordship, the maintenance petition is pending in the family judge Khordha, your lordship. The divorce case is pending, filed by the husband is pending in Bhubaneswar, your lordship.
Yes. What I beg to submit to your lordship, this is the second marriage of the petitioner. In the first marriage, she was divorced, and after that, suppressing the facts, she got married with me. And because my wife died due to corona.
That is why you have filed a divorce petition.
There are also other grounds like cruelty.
Maybe. So how is this court interested with the grounds?
And my lord, and the first marriage and the divorce was passed by the learned family court in Bhubaneswar itself.
Alright.
And thereafter, when I filed the CP, then she filed a petition under section 125 in Khordha.
Yeah, anyway,
And the thing is that, my lord, I am a single parent. And my child is of about age 13 years age. And I have to take
When
her
was the, when was the
my lord.
divorce petition filed?
My lord,
When was the divorce petition filed?
divorce was filed on my lord. My divorce petition, my lord.
Yes.
It was 10/4/2024, my lord.
10/4?
2024. And my this 10/4/2024 what I filed my divorce petition.
10/4/2024.
2024.
2024. When did you file the 125 or what is the other petition? 125.
125.
When did you file?
It is on 13/5/2024.
After filing of the divorce.
Yes, sir.
And she is getting a permanent element of 5 lakhs, my lord. And from
That is a
first
different matter.
my lord.
We are not.
She is staying in a interior village. What is the distance? About 5 kilometers from Khordha. He is not getting any maintenance. He has to travel Bhubaneswar. He has only family member is his father, ailing father. No male member is there to accompany.
You can appear virtually.
There are many family members in her family. Brothers are there.
No, you appear virtually. Allow kudni, huh? Allow kudni virtual kudni.
39.
May I please, your lordship, transfer of civil proceedings from Cuttack to Puri, your lordship. On the last occasion, your lordship was pleased to give a reasonable opportunity to the opposite party. One last opportunity.
Yes. Learned counsel for the petitioner is present. None appears for the opposite party despite repeated calls. The last occasion also, none had appeared for the opposite party. It was adjourned to today to grant an opportunity, grant of one more opportunity. Since there is no appearance on behalf of the opposite party, the transfer application is taken up for hearing. Allow good. Huh?
At number 40, obliged, your lordship.
Email.
Yes.
I think the person concerned has not surrendered because the phone contact number all are not reachable. One of the family member condition was also imposed as per my request matter. Once released on father's ground, mother's illness, sister has sworn the affidavit. Released. I don't think he has surrendered because had it been so, his brother's phone would have been reachable. It's not reachable. I mean,
Ask the court below. The court below is directed to
all punitive, whatever.
inform the petitioner has surrendered to custody after expiry of his interim bail or not. Stop. If not, the court below shall issue NBW to take him to custody again. Hala. This matter. Does in for
20th August.
Huh?
20th August.
20th August. This order will be communicated to the court below.
Item 41.
May I plead on this? On behalf of SS Das, I may permit. My lord, initially he was granted interim bail for 2024.
Yes.
On 24/6, due to his mother ill health, suffering from cardiologic problem, he was granted bail to 6 weeks further. Till her treatment is going on. I pray only for 1 month or 2 months. As a last chance.
It is submitted that the treatment of the petitioner's mother is still going on, for which the interim bail may be extended. Considering the submissions, the interim bail granted earlier is extended by a further period of 4 weeks. It is
My
made
lord,
clear that no, there shall be no further extension.
Today is the surrender date and urgent copy.
Urgent copy
Court
to
submitted.
Item 42.
Item 42, my lord, I filed an IA for interim bill. The ground is that no petitioner has, my lord, transferred kidney, my lord. And I have given the medical certificate along with file an IA. Instruction may be called for from the jail authority, my lord.
Yes.
Both the kidney has been.
Learned State Council shall take instructions. Shall take instructions with regard to the medical documents enclosed to the.
Today I have also filed some
IA.
medical documents.
Further, the condition of the petitioner
See, I have
shall be examined by the jail doctor. Hello? And intimated to this court.
In course of the I have filed some additional document.
That document is fine. Please this matter on 20th August.
Item 43.
Item 43, my lord. I like that passing of cognizance, my lord. Order, my lord.
Why has this come to me?
Your lordship, earlier your lordship has directed because she has granted bail. Subsequently, graver offence was added, and directed to surrender and move for bail on the ratio decided in the Sushila. That's why your lordship filed to. I have filed an your lordship directed to file a. Your lordship has not extended, but directed to file a better application and afresh. So that because there was a delay in filing. That's why
Earlier it was disposed of directing Sushil Agarwal
Yes, ma'am.
to be considered
Yes,
in
yes.
the light of Sushil Agarwal.
Yes,
So what
ma'am.
happened now? No. What happened?
On that is he has not surrendered. I filed an I.
Yes.
Your lordship had ordered it. My lord, 7/3/2024, giving liberty to file.
7/3/2024 in which case?
In this case, in this case, in this case, I have
Where is that order?
that has been. I have written my specific.
No. Where is that order?
My lord, that is CRLMC number 991/2023.
In that case, what was the order?
This was the order. And an extension of time because I have not surrendered during then followed the your lordship's order. And your lordship in the IA direct giving an liberty because there is a filing delay in IA.
So I granted extension of time.
Your lordship has not granted liberty to file a better application.
Better application or better IA file करेगा sir.
Better the lordship
Better application.
better
I have
better
verified the order.
application
you have
99120.
so we will call for the record. Please this matter tomorrow.
That he has challenged the cognizance order.
We will call for the record so that everything will be
your
clear.
lordship that was also uploaded.
Let's this matter tomorrow along with CRLMC number.
CRLMC number
991 of 23.
991 of 2023.
991 of 2023. So
That is also my lord.
let it come tomorrow.
That is also in the.
No, that copy of the order passed is there. That order which you are showing, that order is there. But what was that? The other order which you say that where liberty was granted, that order is not available. So let the record come. Let the record come tomorrow. We'll see.
Yes.
Yes. Item 44.
Item 44.
Last time, my lord, Mr. Who is happy with this?
Any.
Jail superintendent has furnished a report. Madam. That was the prisoner petition. That was all.
It's all right, but as directed, the superintendent, Circle Jail Purbani, has submitted an inquiry report to the effect that the petitioner wanted to change his previously engaged lawyer, as there was delay in grant of stop. The inquiry report be kept on record. This court observes that delay in grant of bail can never be attributed to the learned counsel appearing for a party. Stop. Yes. Oh, it's a 2024. Correct. Yes, sir.
Hello, the occurrence, my lord, 8/8/2023.
Bail applications, when somebody is appearing, you will get it from a person who is in jail, who will mention something, will make some allegation against your professional friend or brother or colleague. Is not a good. This is the only thing that I will observe here. It affects the self-respect and dignity of a lawyer. And in a way, it affects the dignity of the profession, which is considered to be a noble profession. Place this matter 2 weeks after.
My lord, two.
Sub-item your lordship granted interim bail.
1 week.
Put a week for a date could be.
A date please, man.
She called the date could.
My lord.
Sub-item your lordship granted interim bail.
No, sub-item 10553.
11750.
Who is appearing in the other case?
I am.
Again, 10553. Seta
Saubhagya Das.
adjourn 1 week after. Yes, Mr. Devidi, what is the
Sub-item 11750.
That is a dispose of case. I
No
think.
pending.
That sub-item 10553.
In this case, what do you want?
D3, your lordship granted interim bail for a period of 1 month extended. That period has not been yet completed. It will be completed around 13/8 or
Will this matter on
22nd hours.
22nd of.
No, separate.
Separate.
Item 45.
May I please? Yeah, 128 kilogram ganja has been seized and the petition is inside the custody since 8 February 2021, my lord. And some of the co-accused persons has been pleased to call for the report. Out of 16 charge sheeted witnesses, only 4 has been examined recently, for which your lordship has been pleased to release.
Same order will pass, but will not.
No, my lord. They are the financier, my lord. On Raghugula, and they are the local person. This petitioner is from West Bengal. Your lordship see the
from West Bengal?
page 25. Page 25 on Ranjit Samarth. He is the financier, my lord.
Ranjit Samarth actually released on the only man. Those were inside the
Ranjit Samarth.
Ranjit Samarth line. Se hochi Debbo Chalan, Kartik Kirsani, Raghu Khila.
They are the local person, my lord.
Yes.
And one Raghu Khila, who is the financier, your lordship has released, my lord. ଅଛି ନା Raghu Khila ଅଛି ନା page 31. ଏବେ ଯୋଉଟା ଦେଇଛନ୍ତି is the driver of that vehicle and is the local person, my lord.
Debbo Chalan.
Kartik Kirsani. 2 months interim ରେ ଯାଇଛି. Debbo Chalan, he has been released, my lord. Though he was the local person.
These are other bail applications.
So many persons. So some of the persons interim bail has been granted. Subsequently, lots of has been they surrender. Please to grant in regular bail. And so far,
he's an outsider, Mr.
Yes, ma'am.
So for the present person can say he is an outsider, admittedly. But in the meanwhile, 3 years, 6 months, more than 3 years, 6 months.
That I understand, but
may I pray, one of the family member also wants to stood as a surety.
So
that
tell me, What will happen?
If you not surrender, then warrant will be issued in his name.
Warrant issue habo? Warrant issue habo na kon habo? What is the procedure? Mr. Bhukta, gote bailer miscase habo under 446. The court of the CGM for
but he understood.
Let me complete for further compliance.
Right.
And it will be kept pending for the coming, let us say 10-15 years. 15 ବର୍ଷ ପରେ ହଠାତ୍ ଗୋଟେ ସେଟା ବାହାରିବ ଲୋକ ଅଦାଲତରେ ତାକୁ ସେଟଲମେଣ୍ଟ କରିବା ପାଇଁ।
ସେ ସିକ୍ୟୁରିଟି ଆମାଉଣ୍ଟ ଟା ଖାଲି ଫାଇନ
ଆଜ୍ଞା ତଳୁ ଆସିକି ମୁଁ ଜାଣିନି କଣ ହୁଏ ଏସବୁ ଭିତରେ। Why I am so rigid, why don't you understand?
that in the bailer miscase se security amount ta khali fine agar de
The name of Sri Prajit Kumar Pradhan be reflected in the cause list. 36. The name of Sri Prajit Kumar Pradhan, comma, who has appeared for the informant be reflected in the cause list. Yes.
case date be fine
Case diary be obtained.
then wait further more time
22nd. All right. 47.
7th my lord 27
22nd.
22nd
My lord, item number 47 on behalf of Mr. Sashikanta Mishra, kindly adjourn this matter next week.
Next week. Okay. Next week as paid for.
item 48
Regulars. Petition has been implicated on the section where he's wrote to along with other offences. Petition language.
no
And another thing, my lord, some of the eyewitnesses have been examined. I am also
Filing the depositions.
Yes, my lord.
All right.
I am, my lord.
You obtain the case diary.
yes ma'am
Case diary be obtained.
Statement of
Then
one.
you are filing it today.
Yes, my lord.
2024 that you file kari hobo, you file it in the year. Or you keep it at the time of hearing, you produce it.
Yes, ma'am, but I am submitting,
Yes, sir.
giving the.
Learned counsel for the petitioner has furnished copies of the depositions of some of the witnesses
As well as the
examined during the trial
statement
to
of.
the state council.
And also some witnesses whose 164 statement had that they have also.
See, case diary analysis to value. Please this matter.
2nd September.
2nd September. No, out here, go for no.
22nd August.
22nd.
Yes, obliged. Item 49.
May I please, my lord? My lord, in this case, my lord, charge sheet has been submitted against 6 persons. 307, my lord. 307 along with other offences. Charge sheet submitted against 6 persons, and all of them have been released on bail by the Lorraine court below. And as far as the present petitioner, he has been shown as an absconder. May I be permitted to surrender and go on bail?
earlier filed and withdrawn
Yes, yes.
326 386 and 307 allegation is there
What is 386?
Extortion yes
Extortion.
yes ma'am and brutally assaulted so that
No, what is the injury report? Do you have any?
first time it has come out so
You have the charge sheet, Mr. Patnaik?
I have got the charge sheet, but not the injury report.
What
I
does
got
the
charge sheet.
what does the charge sheet say about the injury?
Injury is one of the injured sustained grievous injury.
5 injured person I think there is
The 4 injured.
4 injured
There are 4 injured.
So first or second or parity?
My lord, same day.
Yes. The petitioner is apprehending arrest in connection with such and such case. The prosecution case is that the petitioner and several other persons jointly assaulted the informant by means of
Not the informant.
Oh?
Injured. The informant is the owner.
Assaulted the injured by means of deadly weapons, causing grievous injuries on his body. Sri Patnaik Learned Counsel for the petitioner submits that in the meantime, the co-accused persons have been and that the petitioner stands on the same footing. Considering the submissions as above, first or second or parity?
Parity.
Yes.
Same day. Mine.
No, say that order is there.
My lord, oblige.
Item 50. Resolution 20B2.
Yes, Mr. Rai, you are appearing after a long time.
My lord,
You are not there.
after launch, my lord, I have to remain in my house because of my mother's illness.
All right.
Second half ago.
All right. Yes.
The case under section 20B2C, my lords, of NDPS Act, 2 persons apprehended from the spot. From them, my lord, 180 kg of contraband have been recovered, where they have disclosed that from this petitioner they have procured the ganja. Now those 2 persons
have finished the trial. They have been acquitted. Under Annex 2, I have given the copy, my lords.
Yes, sir.
It's anticipatory bail. Huge quantity, my lord, 180 kg. Admittedly, co-accused statement from they have procured.
Okay.
But case diary is not available, so let the case diary come, my lordship may
All right.
consider.
Up to date, the case diary be obtained. Please this matter.
The 22nd August.
22nd August. Till such time, no course of action.
Obviously.
51.
Without the case diary, we should not dispose.
Yes, 180 kg, my lord.
180 kg is one part. The other
Anticipated
part is
bail.
37 is there.
Yes, my lord.
Section 37 is there. So
Yes.
normally I never do that.
Yes.
Yes.
This matter, my lords, is already disposed of by order dated 27/6/2024, and the transfer petition, my lords, came to be allowed by my lords. Since there are certain typographical errors, it was also corrected by my lords on 16/7/2024.
Then why has it been listed again?
Lords,
Wrongly listed. Why?
there is a noting, my lord, that IA at so and so, my lords, for modification of order, and there is a letter.
IA 204, letter at flag D. Let us see.
Yes.
Case record पठाई ଦେଇଛନ୍ତି why? I am to transmit here with the original case record in mat suit number as per order passed by. There was no such. Was there any such order?
My lord.
There was no such order.
It was simply transfer, my lord. The mat suit
Yes.
transfer.
There was never any such order passed. किसी को देखा है कल हुई थी वो.
Order dated 27/6.
अच्छा, in order dated 16/7/2024, the order number be corrected as order number 4 instead of 7. It appears that the court below has wrongly transmitted the original case record in mat suit number 281 of 2024. Even though there was no such direction. Stop. The case record be returned to the court below.
Just one more prayer, my lords. After your lordship's order dated 16/7, by which that original order was corrected, instead you obtained the certified copy of your lordship's order. I had given it to the office for correction. Your lordships were directed me. That has, I have not taken it back, my lords. Lordships will direct the registry to.
সেটা এখানে অর্ডার পাস হবেনি, সেটা অলরেডি হয়ে গেছে, সো দ্য কোর্ট মাস্টার উইল ডু দ্যাট।
I take it.
One পাস করে কি আমি অ্যাডমিট করব যে আমার ভুল হয়েছে, আমি দেরি করছি বলি। কোর্ট ইজ নেভার রং।
26 was passed over.
Yes?
26.
পাস আউট রাখতে লাগি দে।
Pass over item number 4. To be mentioned.
Item 4. ये था आउथर लॉन्च पर आउथर रखिए, because there is substantial question of lot of frame हो तो yes तापरे।
Pass over item number 5.
Yes, item 5. Item 5 जरा हम देखिए कौन है तो ऑर्डर करिए। None appears disposed of.
Pass over item number 26.
26 is yours, Mr. Das?
Yes. In fact, he has sought for a direction that since he was.
Mr. Panda was here? No. Mr. Bhaskar Panda? We'll take it up on some other day. Does this matter? Next week? Yes, then? Sarla?
May I, if your lordship permits, serial number 1 of the second appeal list, weekly list.
Yes.
If your lordship permits, I can take the LCR by submitting a pen drive.
Yes, yes. I'll pass that order after.
Your lordship.
Oh, you want an adjournment?
Yes.
Well,
because while my associate was conducting it, while discussing, we found that the written statement is not there. That is very relevant.
All right. See the item 1 in the weekly list. You are asking for the respondent.
Respondent. I have talked to my senior.
All right, both sides, we'll see. Learned counsel for the parties are permitted to receive soft copy of the LCR by submitting a pen drive. In a pen drive. Hey, by soft copy
We listed, may I pray from week commencing 20th?
List this matter in the week commencing 20th August.
Obliged.
Okay. Item 2 weekly list, supplementary list is done. And passing orders regarding passing orders on admission of the appeal. It has been inadvertently stated that hearing is concluded and judgment reserved. Stop. Heard CSP Mr. Leonard Senior Counsel with Mr. You are Mr. Das. Mr. G. Mr. G. N. Porida for the appellant. Considering this, peruse the impugn judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial question of law. Whether the courts below were correct in disposing of the matter without referring to the provision under Order 7, Rule 10A. 10 10A of CPC. Issue notice to the respondents by speed fixing a short returnable date. Requisites be filed by day after tomorrow. Peremptorily. List this matter with a short date, Kara?
In the week commencing 27th August.
In the week commencing
7th August.
27th August. Otherwise, it would have been a.
No, actually, I was telling him should have been admitted on that ground. Or
No, I thought of passing that order, somehow it escaped my.
It's good that.
So notice the yes. The
Weekly list. Weekly list.
Your Lordship, and the
Yes.
second appeal
Who's for the other side? Doesn't matter. Yes.
the second appeal has been preferred against the reversing judgment, and the appellants of the second appeal were the defendant number 1 and 2 before the trial court, and they were the respondent number 1 and 2 before the first appellate court. In the
There's
first
an order. There's an order on the last occasion that Mr. CORAM and counsel, the respondent submits that the brief has been taken away from him, but he undertakes to inform in this case. That's a big problem. We'll have to issue notice again. He was there probably in the morning. Somebody has already appeared.
ସେ appear କରିଛନ୍ତି ତାପରେ ଗୋଟେ submission ସେ last ଦିନ
But he undertakes to
and he
inform
was
as to
also
who has appeared.
he was also present today during first hour.
Yes, that was. Did he say anything about it?
ସିଏ ଆଜ୍ଞା ଏଥିରେ
ନ ଆସିକି ସେଟା କଲେ ଯାହା ତାହେଲେ ଗୋଟେ କରିବାକୁ ପଡିବ ଆଦର ନୋଟିସଟା ଯିବ କି କଣ ଗୋଟେ କରିବାକୁ ପଡିବ ନହେଲେ ଇନକମ୍ପ୍ଲିଟ ହେଇଯିବ ମ୍ୟାଟରଟା ୱିଦାଉଟ୍ ନୋଟିସ ହେଇଯିବ ନା
ନା ୱିଦାଉଟ୍ ନୋଟିସ ସେ ଆସିଛନ୍ତି ସେ ଫାଇଲ କରିଛନ୍ତି କାଲି ନା ପରଦିନ ଦେଖନ୍ତୁ ଗୋଟେ
No, last time he said that brief has been taken away from him.
ନା ନା ଡେ ବିଫୋର ୟେଷ୍ଟରଡେ
Okay.
ଗୋଟେ ନୋଟ ଅଫ ସବମିଶନ ଫାଇଲ କରିଛନ୍ତି ଯେ ଯାହା
अच्छी सब ठीक अच्छी. In
No,
the
that's all
second
right.
appeal, it should not be interfered with.
Let it be passed over, you inform Mr. Correct. Correct. Let it be passed over for the day. Tomorrow we'll take it up. You please inform Mr. Kora. Whatever order I want to pass, let me pass it in presence of both sides. If he says that I will not appear, that's a different matter. I can record it and proceed. ये अधारे रहेगा यूज करता
से आसीबी कि नहीं से
है से मना कर दे the court master will find out you do want to inform Mr. Kora हां तो से आसीबन ठीक है we will proceed आज नॉल काली होबो पास हो
Item note 3.
I have that matter, my lord.
res judicata
Yes. Friend has to.
My lord, in fact, I am for the respondents 4 and 5. What I was hearing the submission of my learned
somebody else
friend.
was appearing for the other respondent. You appeared. Both of you are sailing on the same boat.
No, he doesn't have any grievance against me because my deed is not questioned by him. So, if your lordship permits, ask court that how res judicata will happen.
He has made some submissions.
Yes, let him complete.
I only wanted him to observe, to go through that tabular statement that he has prepared so that you will be in a better position to.
So let him address first, thereafter I will conclude.
Have you gone through that?
Yes,
The
I
tabular,
have gone through that. I have also gone through the judgment passed by the Hon'Ble Appellate Court.
whether it will operate as a res judicata. That is the only thing we have to see.
This judgment will clarify the position of law with regard to
Mr. Bose?
Yes, sir. Well, for his side, the judgment, that one adva judgment by.
say that text to already.
The law.
Let us go to that note.
Yes, sir.
Mr. Satpathy, you had filed a note.
My lord.
Tabular এটা কোথায় রয়েছে?
Para 11, 10, 11.
The only thing is that you have to make your submissions with regard to paragraph 11.
Res judicata.
Para 11 is he has given a comparative chart. And that too only the subject matter and the decision. These are the two things that you have to see. In the first case, the subject matter was part of the decree refusing to declare the sale deed in respect of schedule C and E. In the second, it was with regard to the will. Yes.
His the note of submission filed by the appellant concerned matter. The issues are different. So far, his contention is that many issues are different. The agree portions are different, and the appellants are different. That's only my note.
No, subject matter is also different.
Subject matter is different. But so far as the res judicata is concerned, my lord, res judicata is concerned, as held by the Honorable Supreme Court, my lord, there are some criteria. If his case falls within that criteria, my lord, all the res judicata will not applicable. If that does not fall within that category, res judicata will be applicable. That is the latest Supreme Court law, my lord. I was just submitting that judgment before lordships, my lord. Just placing that judgment. Res judicata, the general principle of res judicata under section 11 of CPC contain the rules of conclusiveness of judgment, but for res judicata to apply, the matter directly or and substantially in issue in the subsequent suit must be the same matter which was directly and substantially in issue in the former suit. Further, the suit have been decided on merits, and the decision should have attained finality. where the former suit is dismissed by the trial court for want of jurisdiction, for default of the plaintiff's appearance, or on the ground of non-joinder or misjoinder or multifariousness, or on the ground that the suit was badly framed, or on the ground of a technical mistake, or for failure on the part of the plaintiff to produce probate or letter of administration or succession certificate when the same is required by law to entitle the plaintiff to a decree, or for failure to furnish security for cost, or on the ground of improper valuation, or for failure to pay additional court fee on land which was undervalued, or for want of cause of action, or on the ground that it is premature and the dismissal is confirmed in appeal, if any, this decision, not binding on the merits, would not be res judicata in a subsequent suit. In the former suit, my lord, he has participated, my lord. It is not that he has not participated, my lord. That has attained its finality, my lord. And he has not filed he has not come to this forum also, my lord, against that finding, my lord, in the former suit, my lord. That is in the appellate court judgment, my lord. I will draw your lordship's kind attention to appellate court judgment, my lord.
He says that the matter, because of the judgment, passed in another appeal, which is RFA 42 of 17.
My lord.
Now, he has tried to make a distinction between the two judgments, saying that the subject matter of challenge in both the appeals, appeal, let us say suit, it's
My lord.
continuation of suit, so doesn't matter. So that appeal is different. That he has made a, sort of a comparative analysis by saying that in that 42, what was under dispute was the refusal to declare the sale deed in respect of property as invalid. In this appeal, the validity of the will under Exhibit A and alienation in respect of Schedule B and D is under challenge. So, according to him, this is on a different cause of action altogether, different subject matter rather. The subject matter is totally different. So, the decision in the earlier appeal will not operate as res judicata. You have to answer that.
My, it will operate, my lord. That is
It
will operate, my lord. It starts from para 7, I think. 7, 8.
Appellate court judgment.
Appellate court judgment. 8 onwards, my lord.
Yes.
It has been clarified. 9.
Yes.
On perusal of the record of the issued on perusal of the record of the learned court below, it appears that there is a copy of the judgment passed by this court on 28/11/2005 by RFA number 42/78 of 2005, arising out of the impugned judgment and decree. It is clearly evident from judgment dated 28/11/2005, passed in RFA number 42 of 78 of 2005 that the same was preferred against the same judgment and decree of the learned court below, which is the impugned judgment and decree of this appeal, and the parties to this appeal were the parties to the same, and the same has been dismissed on merit.
So he has taken the fact. Mr. Bose, would you like to assist the court in this regard? The point is very, very pinpointed.
Yes.
Very limited point. If the court holds both the appeals are different,
yes,
call it 42. For convenience, that was 42, this is 43.
43. But against 40, learned trial lower appellate court, while deciding 43, stated that your lordship may, with your lordship's kind permission, may I place paragraph 11. As stated above, when it is crystal clear that an appeal-wide RFA number 42 of 78, 42/78 of 2005, arising of the self-same judgment and decree of the learned court below, has already been decided between the parties in merit on contest on 28/11/2005 by this court, when at this juncture there is no justification under law to redecide the same again, because the said matters in controversy between the parties has already reached its finality in judgment dated 28/11/2005, passed by the court in RFA number 48/78 of 2005. It is the law that once the decision is rendered inter partes by a competent court, your lordship may kindly mark the word inter partes by a competent court, and attains, then a different view cannot be made by the same court like this court, though another matter like in this appeal. The re-agitation of the self-same matter may encourage multiplicity of findings for which the same has been prohibited under the law. So this was the basic finding of the learned appellate court, which against which they have come up stating that the point of decision and the point of determination in both different. But my lord, we should not forget one point. It arises of a common suit. In the common suit, there is respective pleadings of both the parties. While deciding that pleading, certain issues are casted. In those issues, certain findings are entered. Some parties challenge one finding, some parties challenge another finding. This first appeal being dismissed on merit, the previous dismissed on merit, having not been questioned before this honorable court in a second appeal, finding remains binding on him. Because suppose, my lord, the finding is there against me. Some other person challenged it. I don't challenge. Means I accept that finding against me. I accept that finding against
Mr. Bose, I'll make it easier for you to answer.
My lord.
There are 4 issues.
Yes.
Issue 1, 2, 3, and 4.
Yes.
Findings on issue 1 and 2 are challenged by, let us say, A.
A.
3 and 4 are challenged by B.
Yes.
In that appeal filed by A,
yes,
the finding have not been touched. So the finding, whatever the finding the first appellate court gives, is in respect of only 1 and 2.
Correct.
He doesn't touch 3 and 4 because there is no appeal.
No.
So can B be precluded to file an appeal raising the correctness of the finding under 3 and 4?
My lord, I will answer. Yes,
this is as they say, to put it very succinctly.
Yes. My lord, I answered in this way, subject to your lordship's kind acceptance. My lord, the or a making of a written statement, we take all the points of the plaintiff and dispute the same. In this case, there were 4, admittedly, there were different issues. 2 issues went against me. I have questioned those 2 issues in the first appeal. 2 issues went against him. Here, it was questioned in another appeal. My lord, when an appeal is filed of a common judgment, the appellant of the second appeal should have been vigilant that yes, both the appeals should be tagged together.
That is the usually heard together.
Yes. Having not been vigilant, my lord, now he comes up in this second appeal and says that 2 appeals are on a different issue. My appeal on a different issue. So my appeal has to be decided independently. Can the court decide it, my lord?
Yeah, that is the question to be determined.
Yes. My lord, a person who does not knock the doors of justice at the right time cannot come up in appeal and say that I was not allowed to knock the doors of justice.
No, I put it in a different manner. 42 was filed by one party. 43 was filed the next appeal. Next appeal.
Was he not noticed, my lord?
No. It was incumbent upon the court to tag the appeals.
My lord, let us not put blames on court.
No, it's not a question of putting the blame. It is the question of adopting a proper procedure.
Correct. Suppose, my lord, the court has not adopted the proper. Was he not noticed in that case? Was it not within his knowledge that the another appeal is pending? What prevented the client to approach the court by filing a petition that both are in the same court? It may be decided analogously. He chooses not to bring that to the court. And now he puts a blame that the court. You cannot shift the burden of responsibility on another party, on the court, saying that court should have done it. What prevented you? Was that appeal the hard ex parte without notice to you? No. My humble submission would be it is not that. He was noticed. He was a party to the suit. He was noticed in the appeal. He did not choose to come to court. Once having not availed that opportunity, now he cannot turn back and say, as a fence, that court should have done that. And the material which was placed before the learned first appellate court, while deciding this second number 2 appeal, the court below proceeded on that notion. All right. And my lord may kindly see the chart. Your lordship may kindly see the chart. Paragraph 11.
Yes.
We are concerned with 42, my lord, now.
42.
Your lordship may see the subject matter. Part of the decree in refusing to declare the sale deed in respect of C and E scheduled property are invalid. This portion is what? Declaration made by the trial court with regard to validity of exhibit A and the alienation in respect of B and D property as invalid. The finding with regard to status of Bhujo as son of Bimbadhar was challenged. So, my lord, there are 4 sale deeds. A, B, C, and E. When those sale deeds are tested in the trial court, the status, the authority of execution of the sale deed is also gone through. Maybe the learned trial court gave a different finding on all this, but while deciding that sale deed, the status and the competency of the person in executing that sale deed or competency of the person in executing the will is also tested. These two, maybe 2 different parties challenge the same, but the competency of execution of the sale deed, the competency of executing the will is there now. And he having not becoming a fence sitter, having not taken that option of joining the appeal, what should have
finding of the appellate court is confined only to this.
Res judicata.
You know, in 42, the finding of the court is confined only to that sale deed in respect of schedule C and E. Relating to validity of will or whether Bhujo was the son of Bimbadhar, etc., has not been gone into. That is exactly what he wants.
It need not go in. My submission would be he need not go into. The trial, when in a second appeal we come up before your lordship, we make out a case of a particular question of law or multiple questions of law which your lordship will answer. But while deciding that, my lords also see the judgment of the learned trial court as well as the appellate. The learned trial in the fact-finding court has dealt about the competency of execution of the document. Maybe it may be different property. Whether that property has rightly gone to X or Y will be decided in the later stage. But whether A had the competency to execute the sale deed or not is a general thing which will be decided by the learned appellate court. So, my lord, when that general principle was decided in the previous first appeal, and that he should have challenged the same in a superior court of law, he has not challenged in the superior court of law. Now he turns back and says that that was on a different context, this was on a different context, so res judicata will not apply. But here, my lord, my humble submission would be, it will be barred by 77 Supreme Court, that is constructive res judicata.
He could have challenged.
He could have challenged. He has not challenged the same. Now, when he has lost everywhere.
Anyway, the point is taken.
Yes.
Let us not deal with it any longer. Would you like to add anything to it, or I'll close it? Yes, it
My lord, in fact, he has no grievance against me, but as an officer of the court, I am assisting.
That is it.
In addition to my lord, I am giving the one additional citation.
Yes.
जोटा के 53 Supreme Court कहना, even if two appeals यदि file ହେଇଛି, then the disposal of the first appeal cannot be a res judicata for the second.
Let us examine. It's a very interesting point. Let us examine. Heard arguments. Judgment reserved. Parties may file their note of submissions and memo of citations, if any, within a week.
My lord, I'll just supply that 77 Supreme Court.
Please.
ସେଇଟା ତ
But the memo,
So 53 more 77.
Mr. Bose, with a memo.
Yes.
ମାନେ 77
Yeah, we have also done it.
All right. Yes, item 4.
Item 4.
My lord, item 4, my lord. On behalf of Mr. Devashish Tripathi, his uncle is suffering from cardiac problem. Now he's the treatment in the.
The third time is taking time.
So I pray next tomorrow, just tomorrow. I pray.
The password, sorry.
Password. Tomorrow.
All right, password. Password for the day. Ask him to appear for the third time is taking time. Yes. Item 5.
Item 5, your lordship, last occasion directed to for a settlement of parent, and we have joint petition.
बढ़िया ना
Let's see, one point I am raising here.
ओडिया रे कोई नहीं रफा तो बड़ी बड़ा रफा नहीं
I am agree all his conditions.
है ना whatever you why the court will intervene.
One point I am raising here, lordship. They reflect my Eco Bank account number. Now my only prayer is automatically from his salary account.
More deposit code. That is
ସୁବିଧା ହୁଅନ୍ତା ମତେ ସେଇଟା ନହେଲେ କଣ ହଉଛି କି ଦେବେ ଆମେ ମନା କରୁନୁ ତାଙ୍କର ସ୍ତ୍ରୀ ସେ ଦେବ ବୋଲି ତ କହୁଛନ୍ତି ଧର ଏ ମାସର ଛାଡିକି 2-3 ମାସ ଲେଟ୍ ହେଇଗଲା ଏଇ ଅସୁବିଧା ହଉଛି ତେଣୁ ତାଙ୍କର ଏଇଟା ଯଦି ଟ୍ୟାଗ ହେଇଗଲେ ଅଟୋମେଟିକ ଯଦି ବ୍ୟାଙ୍କ ତାଙ୍କ ପଳେଇ ଆସିଲେ ସୁବିଧା ହବ
ସେଇଟା ମୁଁ ପ୍ରତି ମାସରେ ଦଉଛି ବୋଲି ଲାଷ୍ଟ କେତେ ଦିନ ବି ଦେଇଥିଲି ଏ ମାସରେ ଯୋଉ 34,000 ଟଙ୍କା ବି ୟୁକୋ ବ୍ୟାଙ୍କ ରେ ଦେଇ ଦେଇଛି ତେଣୁ
I think this decree has to be drawn up by this court. All right. Joint application.
Para 3 ta your lordship.
Application for compromise has been filed by the parties in court. Same be registered. It is stated that the parties have settled their dispute amicably on certain terms and conditions as indicated under paragraph 2 of this petition. In view of the amicable compromise, the second appeal is in terms thereof. The terms of compromise shall form part of the decree, which shall be drawn up accordingly. That's all.
ଏଇଟା ଟିକେ ଆଣିଥିଲେ ଭଲ ହେଇଥାନ୍ତା
Diploma. Item number 6.
The settlement ହେଇଗଲା ଆଜ୍ଞା ଆଉ thanks to learned counsel for all both the parties ଆଉ 3,000 ଟଙ୍କା 5,000 ଟଙ୍କା ସେଥିପାଇଁ ଆଜ୍ଞା litigation anyway yes ये କାଗଜଟା ଦେ ହେଲା so we'll frame the substantial questions first.
I have made a draft. I am giving a copy to my friend.
Formally admit करे तो LCR is there, everything is there. Formally admit. So today we will devote half an hour time, and tomorrow again we'll continue. What do you say? Subject to availability and convenience of
দুইটা পরে হলে কিছু অসুবিধা নাই
দুইটা পরে ହିଁ ତ ହବ দুইটা ପୂର୍ବରୁ ତ ମୁଁ
কিছু অসুবিধা
why I am saying is that other matters are there. ଆଜି ଘରେ ଅର୍ଡରଟା ପାସ୍ କରିଦୁ କୋଉ ସବୁ ତ ହବନି ଆଜ୍ଞା
ସବୁ ଗୁଡାକ substantial. My friend may examine it. On consent, it may be.
କଣ କହୁଛୁ ସବୁଗୁଡା
ସବୁ ହବନି
ଦେଖିଦିଅ
ଦେଖିଦଉଛି one ଆଜ୍ଞା that is completely factual aspect assuming there is irregularity is curable it is not illegal but irregular again on the last occasion my land senior submitted 2 decisions more than 6 decisions on that point.
I may frame some of the questions.
Yes, but that is not a
But that will
substantial
not stop, sir, that will not stop you from arguing on other points also. So that formally
That will be indicated.
Formally, heard Sri Vidyadhar Mishra, learned senior counsel with, I'm sorry, I'm forgetting your name. A.K. Biswal. T.K. Biswal, learned counsel for the appellant, peruse the informed judgments, considering the submissions and the grounds raised, the second appeal is on the following substantial question of law. Number 3 ta karantu.
Again, one taku karantu, I have already addressed your lords.
All right. 1, 3, 5.
What have we got? Cause of factor.
Acha, 1, 2, 3 and 5.
Man, again.
8 ta karantu.
Again.
9 term.
10.
9 term.
Yes, it is factually used. 8. Since the respondents have already entered appearance, and it is stated at the bar that the matter can be finally disposed of at this stage, hearing of the appeal is taken up. Yes. Sir, you have already argued of one part.
थोड़ा का टाइप हवा दरकार होना चाहिए खाली पॉइंट नंबर 1 2 3 कर देल हवा नहीं
इसी करिए ना
आगे
to save time normally in other cases you must have seen the entire thing, but this time
point number 1
since a stalwart like sir is appearing, I will not venture into making any further. I may not agree with him. That's a different matter. What do you say, Mr. Ponda?
Nothing to say. I'm only senior, sir.
No. You have learnt your trade from, I will not say anything here.
not that well said.
No, I did not say anything.
Point number 1 रे मु गोटे डिसीजन साइट करिवार रहि जाइतिला कैन आई
So you are cited.
No, आज रहि जाइत जोटा
You have cited 2011 Supreme Court.
2013 date.
Oh, 2014, yes.
आपन पाखरे अछि ना ओटे
2014
AC Narayanan versus State of Maharashtra. Yes.
2014 11 SCC 790.
So your main plea was that the very presentation of the plate is bad. So this 2014. Three. We will close at 3:15, sir.
3:15.
Sir.
Before that I may close. I will only cite this decision and reserve it for tomorrow or day after tomorrow, whatever.
I would
नहीं सर 3:15 का टाइम अच्छी करो
नहीं आज आउ दुईटा डिसीजन मु दउची से दुईटा को पॉइंट नंबर 1 ऊपर मु दे दउची let my learned friend examine it.
Okay, so this is 2014.
Yes.
May not come to 798. Case number 798. I have highlighted.
798.
12, 13.
Yes.
A division bench of this court, your lordship got it?
Yes.
On 4/1/2007, while considering criminal appeal number 73 of 2007, arising out of special leave petition criminal number 6703-08 of 2005 with regard to the interpretation of section 142A of the NI Act, observe that in view of the same, it is desirable to extract the entire order of the reference with as under. Delay in filing the counter affidavits is condoned, leave granted, interpretation and or application of Section 142A of Negotiable Instruments Act 1881 NIR is in question in this appeal, which arises out of a judgment and order dated 12/8/2005 passed by a single judge of the High Court of Judicature, Bombay. The basic fact of the matter is not in dispute. Several checks on different dates were issued by the appellant herein, which were the complainant executed a special power of attorney on or about 28/11/1997 in favor of Srimati Doreen Sheikh. She filed complaint petition in the court of the Additional Chief Metropolitan Magistrate, Bandra, Mumbai. The complaint petitions were filed in the name of respective payers of the checks. She also filed affidavits in support of the averments made in the said complaints. Cognizance of offences under Section 138 of NI Act was taken against the appellant. Summons were issued. Questioning the order issuing summons by the learned magistrate in exercise of his power under Section 204 of the Code of Criminal Procedure, the appellant herein filed criminal application before the High Court of Judicature, Bombay, inter alia contending that the complaint petitions filed by the power of attorney holder are not tenable, and relying thereupon or on the basis thereof, the learned magistrate would not have issued summons. The said contention has been negatived by the High Court in its impugned judgment. In the aforementioned premises, interpretation of Section 142A of the NI Act comes up for consideration before us. We may notice that MMTC Limited versus Merchal Chemicals and Pharma Private Limited, a division bench of this court, has opined, SCC page 238, paragraph 11. This court has, as far as back, Vishwamitra versus O.P. Poddar, held that it is clear that anyone can set criminal law in motion by filing a complaint of facts constituting an offense before a magistrate entitled to take cognizance. It has been held that no court can decline to take cognizance on the sole ground that the complainant was not competent to file the complaint. It has been held that special statute prescribes offences and makes any special provisions for taking cognizance of such offences under this statute. Then the complainant requiring the magistrate to take cognizance of the offence must satisfy the eligibility criterion prescribed by the statute. In the present case, the only eligibility criteria prescribed by Section 142 is that the complaint must be by the payee or the holder in due course. This criteria is satisfied as the complaint is in the name and on behalf of the appellant company. However, in a later judgment in Janki Vasudev Bhojwani versus IndusInd Bank Limited, albeit a different context, another division bench of this court overruled the judgment of Bombay High Court in Pradeep Hon'Ble versus Miguel Across Diaz. Inter alia, opining that as follows. SCC Order 3 Order 3 Rule 1 and 2 CPC empowers the holder of power of attorney to act on behalf of the principal. In our view, the word acts employed in Order 3 Rule 1 and 2 CPC confines only to respect of acts done by the power of attorney holder in exercise of powers granted by the instrument. The term acts would not include deposing in place and instead of the principal. In other words, if the power of attorney holder has rendered some acts in pursuance of power of attorney, he may depose for the principal in respect of such acts, but he cannot depose for the principal done by the principal and nor by him. Similarly, he cannot depose for the principal in respect of the matter of which only the principal is entitled to be cross-examined. On the question of power of attorney, the High Courts have divergent views. In Sambhudat Shastri versus State of Rajasthan, it was held that a general power of attorney holder can appear, plead, and act on behalf of the party, but he cannot become a witness on behalf of the party. Here, in his own capacity, no one can delegate the power to appear in the witness box on behalf of himself. To appear in a witness box is altogether a different act. A general power of attorney holder cannot be allowed to appear as a witness on behalf of the plaintiff in the capacity of the plaintiff. However, in Humberto Luis versus Floriano Luis, on which reliance has been placed by the tribunal in the present case, the High Court took a dissenting view and held that provisions contained in Order 3 Rule 2 CPC cannot be construed to desensitize the power of attorney holder to depose on behalf of the principal. The High Court further held that the word act appearing in Order 3 Rule 2 CPC takes within its sweep depose. We are unable to agree with this view taken by the Bombay High Court in Floriano Armando. It is not in dispute that there is a conflict of opinion on this issue amongst various high courts, including the decisions of the Bombay High Court in Mamata Devi Prafulla Kumar Bhansali versus Pushpa Devi Vilas Kumar Agarwal on the one hand, and the decision of the Andhra Pradesh High Court in SP Sampati versus Manju Gupta on the other. One of the questions which would arise for consideration is the eligibility criteria prescribed by Section 142A of NI Act would stand satisfied if the complaint petition itself is filed in the name of the complaint payee or the holder in due course of the check, and or whether a complaint petition has to be presented before the court by the payee or the holder of the check himself. Another issue which would arise for consideration is as to whether the payee must examine himself in support of the complaint petition, keeping in view the insertion of Section 145 of the said Act. In our opinion, in view of the difference of opinion amongst various high courts, as also the decision of this court in MMTC Limited and Janaki Vasudev Bhojwani, particularly in view of the fact that in the latter case, the earlier one was not noticed, an authoritative pronouncement is necessary to be given in this regard. We therefore are of the opinion that considered by a larger bench. This was the reference. Now,
8-0.
Kindly come to page 804. Paragraph 24.
24.
Yes, madam. Now, let us consider the latter decision of this court in Janaki Vasudev Bhojwani. This case relates to the power of attorney holder under the Code of Civil Procedure 908-190. It was concluded that a complaint by a power of attorney holder on behalf of the original plaintiff is maintainable, provided that, this is material minor, provided he has personal knowledge of the transaction in question. And then kindly come to page 26. Paragraph 26 at page 806. As noticed herein above, though Janki Vasudev Bhojwani attorney holder under CPC, but it was concluded therein that a plaint by a power of attorney holder on behalf of the original plaintiff is maintainable provided he has personal knowledge of the transaction in question. Then, let's see. Kindly come to last. Paragraph 33. While holding that there is no serious conflict between the decisions in MM and Janki Vasudev Bhojwani, we clarify the position and answer the question in following manner. Filing of complaint petition under section 138 of NI Act through power of attorney is perfectly legal and competent. 33.2. The power of attorney holder can depose and verify on oath before the court in order to prove the contents of the complaint. However, the power of an attorney holder must have witnessed the transaction as an agent of the pay holder in due course or possesses due knowledge regarding the said transactions, which I have drawn to your lordship's kind attention in on oath before the court, trial court, that I have no knowledge about the contents of the plant, nor I have any knowledge regarding the transaction under Exhibit A and Exhibit B. Therefore, I was contending with your lordship that the suit is not maintainable at the behest of the power of attorney holder. It is required by the complainant to make special assertion as to the knowledge of the power of attorney holder in the said transaction explicitly in the complaint. The power of attorney holder who has no knowledge regarding the transaction cannot be examined as a witness in the case. In the light of section 145 of NI Act, it is open to the magistrate to rely upon the verification in the form of affidavit filed by the complainant in support of the complaint under section 138 of the NI Act, and the magistrate is neither mandatorily obliged to call upon the complainant to remain present before the court, nor to examine the complaint witness upon oath for taking the decision whether or not to issue process on the complaint under section 138 of the NI Act. The functions under the general power of attorney cannot be delegated to another person without specific clause permitting the same in the power of attorney. Nevertheless, the general power of attorney itself can be cancelled and be given to another person. We answer the reference on the above terms and remit. Now, decision also I am giving. Last decision of 2024.
INSC 293. 2024. INSC 293. Monisha Mahindra Gala and others. Monisha Mahindra Gala
and others.
Shalini Bhagavan.
Yes.
Of Travel.
I think para 28 you have highlighted.
Mine. Yes. May I please?
Yes, please.
The law as understood earlier was that of a general power of attorney holder, though can appear, plead, and act on behalf of a party if he represents, but he cannot become a witness on behalf of the party represented by him as no one can delegate his power to appear in the witness box to another party. However, subsequently in Janaki Vasudev Bhojwani versus IndusInd Bank Limited, this court held that the power of attorney holder can maintain a plaint on behalf of the person he represents, provided he has personal knowledge of the transactions in question. It was opined that the power holder or the legal representative should have knowledge about the transactions in question so as to bring on record the truth in relation to the grievance or the offense. However, to resolve the controversy with regard to the powers of general power of attorney holder to depose on behalf of the person he represents, this court, upon consideration of all previous relevant decisions on the aspect, including that of Janaki Vasudev Bhojwani Sopra in A.C. Narayan versus State of Maharashtra, which I previously cited.
Yes.
Concluded by upholding the principle of law laid down in Janaki Vasudev Bhojwani Supra and clarified that power of attorney holder can depose and verify on oath before the court, but he must have witnessed the transaction as an agent and must have due knowledge about it. The power of attorney holder who has no knowledge regarding the transaction cannot be examined as a witness. Functions of the general power of attorney holder cannot be delegated to any other person without there being a specific clause permitting such obligation in the power of attorney, meaning thereby ordinarily there cannot be any sub-delegation. So these are the three decisions, and I would say
yes.
Whatever rest is left to be submitted on this point, I will submit it on the next day whenever it is.
Tomorrow? Yes, Mr. Bag.
Yes,
Tomorrow
after.
It may be called a day after tomorrow because I am
tomorrow personally in person
having
case
a running
fix
note.
ଦୁଇଟା ବେଳକୁ
He's actually he's actually having a running.
consider Wednesday ମୋର ନିଜ case ଗୁଡା fix ହେଇଛି
Thursday, huh? खाली पास ओवर था लिखि दियो मार्क कर दियो थर्सडे बोल या एटा को रखा था
ना लिस्ट रे रहिबो खाली
लिस्ट ए जो ऑर्डर डाकिले एटा जो दिन कंप्लीट होबो से दिन ए ऑर्डर
आइया
Item number 7.
Seven minutes. I will seek some time minutes to prepare. I will seek some time to prepare.
No, this is for setting aside a substitute.
आइए अच्छी किंतु ये लॉर्डशिप ऑन लास्ट ओकेजन कहते 20 years रो डिले अच्छी याको एकाथरे सुनी दवा जदी किछि मेरिट थियो देन ओनली आइए अलाउ करिवा नले एकाथरे डिस्पोज ऑफ हे जीवो तो सेति पई से आइए गुडा अच्छी फ्रॉम लास्ट ओकेजन
Okay. So you have not prepared. Have you taken that LCR soft copy of LCR?
Plus I have taken. Plus I have not taken.
Why?
Plus.
Why are you not showing some promptitude? You are a young lawyer. Take the soft copy through on a pen drive and prepare. Item 8. Yeah, it pass on it adjourn कर दियो. As requested by learned counsel for the appellant, let's this matter
20th August.
In the week commencing 20th August. Prepare.
Yes, I will take the LCR in pen.
Yes. The already order he got you notice asla apun nahi nante you take that. I think Mr. Rao is there. Let me still inform. Yes, sir. He wants a time. He wants time because I have asked him that because there is a delay of about 20 years.
20 years.
So if there is any merit, if I find any arguable case, then only I will allow the IA and hear it on merit. If there is nothing to be decided in the appeal,
indicated.
Yes. So he wants some time. We'll take it up on week commencing 20th August. Yes.
Item number 8.
9A return with the postal
Notice on
report address.
substitution notice.
Long day out of station. तार माने कौन? Take notice, fresh notice आप कौन करेंगे? Long day out of station. तार माने कौन?
Other are there. Distant relatives are residing within the house, but he is absent.
Who is he?
He is the son of the respondent number 9.
Respondent number 9. Number 1. ये बोलिए ना 9 किम दो. Respondent number 9A. Sorry, they have mentioned it wrong. Address is long day out of station. Let us see. Who is 9? Respondent number 9 is the original respondent has been substituted by 9A. 9. Who has been substituted? His son.
Yes, his son. Paragraph 3. Benu Behera, son of that Goranga Behera.
So, postal tracking report. No, item delivered. Item delivered. No. To whom was notice issued? Otherwise,
Notice was issued to Benu Behera. And they have mentioned the address at paragraph 3 of my substitution.
Mr. Mishra. The postal tracking report relates to some other respondent. So here either you take fresh notice or if you can prove that there is substantial representation, I can dispense with. Who is the respondent number? Let us see your substitution petition when you Gauranga Behera. Gauranga Behera's son is Benu Behera. How is he related to respondents? Yes. Gauranga Behera, the deceased, you have not mentioned his father's name.
Yes.
Take fresh notice. Issue fresh notice on respondent number 9A by both ways, by registered post as well as through court process. Requisites shall be filed, will be filed within 3 working days. Notice be made returnable within 4 weeks. Let this matter.
So we commencing 17th September.
In the week commencing 17th September. Yes.
Item number 9.
9, my lord, there is only one respondent. In fact, it should not have been respondent 4 to 6. Inadvertently, it has been so typed.
In order dated 22/7/2024, in paragraph 3, the words numbers 4 to 6 be deleted. So have you filed the requisites?
Yes.
Right. Notice was issued. No, notice issued.
Notice was directed to issue. Requisites were filed.
Not
on the sole respondent on 23rd of July.
Notice be issued as directed. List this matter. That is 9/9/2024. Yes.
Item number 10.
Item 10, Your Lordship, on behalf of Mr. Biswal, I'm appearing for respondent number 1, Your Lordship.
Respondent number 1.
My Lord.
Okay, let us see. 4 and 6.
I am for the appellant, Your Lordship.
Respondent number 3 with the report address left from up to number 7, the postal no such address from 9 with the postal report left to the administration. You have to take notice then again.
Your Lordship.
Fresh notice. Can you appear for the other respondents?
Instruction, I will only appear for respondent number 1, Your Lordship.
Respondent number 1. All right. Issue notice, issue fresh notice by both ways on the non-served respondents. That is respondent number 3, 4, 6, 9, 10 and 13.
7
7 is also there.
7 is also.
7 ta coil with it? 7 by both ways, by registered post as well as through court process. A short date be fixed. Requisites be filed within 3 working days. List this matter.
17 September.
In the week commencing 17th September.
Interim order to continue.
Interim order to continue.
Obliged.
11.
11 matters, I think we both the counsel, Mr. Bag, myself, we are trying to have a settlement. I pay some time so that the date may be fixed in between. If there will be a settlement, it's all right. Otherwise, we'll proceed.
Earlier, once a settlement has failed, a short date may be fixed.
It is stated at the bar that attempts are being made to resolve the dispute amicably out of court. Such being the submission, let's this matter on
In the week commencing 20th August.
in the week commencing 20th August.
27th of August.
27th of August?
Oh, my.
All right, 27th of August. No, week commencing 27th of August.
We commencing.
Item number 12.
May I please, Your Lordship? May I please, I am sorry, Your Lordship. But the respondent number 14 expired. I had to file on substitution application in fact.
All right.
But respondent number 15 is available, which is on record.
All right.
So I have filed one memo to that respect. On 4/7/2024, which is available.
In will a memo do?
Whenever one his date is no need for substitution.
Yes, Mr. Das. Will a memo do?
Yes, yes.
I had not followed what.
No, when somebody is already on record, other LR is already on record, no substitution is necessary. Can that order be passed on the basis of a memo?
That depends on Your Lordship.
Yes. No, why I am asking, I know. Because very recently, in a matter, one of the, in Calcutta High Court, they said that you have to file a petition. And maybe notice has to also be issued. And then you'll have to pass that order. When somebody told me, I said, we are passing routine orders. Respondent number 14.
Dead person's name to retain. To be.
Yes.
Dead person's name is also to be retained. That is the law.
How? Respondent, the other, his LR is stated to be on record.
Yes.
According to a memo, so we'll refer to that memo and pass an order at his risk.
No, but why?
It is stated that respondent number 14, Sukha Behera, has died. The counsel for the appellant has, however, filed a memo stating that Sukha Behera died, leaving behind his only daughter, namely Koili Behera, who is as his only LR and who is already on record as respondent number 15. As such, no substitution is necessary. In such view of the matter, this court holds that no substitution is necessary. Vice respondent number 14, as his sole surviving LR, respondent number 15, is already on record. This order is passed at the risk of the appellant. Yes. What is the further? I would want respondent number 3. Respondent number 3. Office note. What does the office note say? Due to time barred. Notice could not be served on respondent number 3.
Accept the notice.
No, notice has not been served. Take fresh notice.
Yes, Your Lordship. I will take.
issue fresh notice to respondent number 3 by registered post? No, it has been served. It has been served. Notice on respondent number 3 has been served. Has been personally served. There is, however, no appearance. Hello. Is this otherwise ready for hearing?
Yes, Your Honor.
Substantial question framed?
Yes, it is admitted, Your Honor.
So we'll list it for admission. For hearing, we'll list this matter for hearing on.
But I have an IA number
Where is that IA?
394 of 2019. Status code is passed by the Honorable Court. I filed this application under section 151 of CPC seeking for police help because the respondents, they are disturbing in the possession.
That was filed in 2019.
Status code of the 2000, yes.
Was any order passed on that petition?
It was hard, but subsequently, it is adjourned day by day. Then it was not.
No, it has said that some interim order was passed.
It is all interim order was passed on 27/6/2008.
So then it will continue. Okay?
Yes, Your Honor.
List this matter for hearing in the week commencing 2nd September. Interim order to continue.
It may be posted for hearing. Your Honor.
Hearing to lekha.
Yes, deeply.
Item note 13.
That is
There's a defect.
defect malware, only defect malware that is in the plate, in the suit malware, the name of the petition was later the Dhoya Samar. But in the appeal malware, he did the Dhobi Samar. And I am the respondent. I am the opposite party malware. I am the defendant in the case malware. His name malware in the page number 8. Name was Dhoya Samar.
Dhoya Samar.
Yes. And in the district judge court malware, in the it was dated Dhoni Samar. Page number 8.
Dhoya Samar. No, acha. It appellate court judgment. Dhoni Samar. So you should have corrected it in the first appellate court.
Because first appellate court, he has filed the suit.
Okay. So now you have filed.
I have filed because it is a reversing judgment.
So we'll have to ignore it.
Yes, my lord.
CDK Pondal and counsel appearing for the appellant admits that the name of respondent number.
Name of respondent number, my lord. State respondent number.
Respondent number
1, my lord.
Respondent number 1.
Yes.
Is actually Dhoya Samal, DHOIA Samal, Dhoya Samal, as reflected, as stated by him in the trial court. Plaintiff number 1, therein. So, the first appeal was, however, preferred by the first appeal was, however, preferred by defendant number 1. The first appeal
by the respondent.
However, in the first appeal filed by him, he described his name as Dhoni Samal. Which was never corrected. Since the defendant number 1 is the appellant before, it is prayed that the defect pointed out by the SR, defect pointed out by the office as regards the discrepancy in the name of respondent number 1 be ignored. Stop. Perusal of the judgment of the trial court reveals that plaintiff number 1 has been described, has been indeed, and has in fact been DHOIA Dhoya Samal. In the judgment passed by the first appellate court, the name is mentioned as Dhoni Samal. Stop. Under such circumstances, the defect as pointed out by the office is hereby ignored. Yes, admission kar ready?
Yes. Good. The case is, my lords, that is the suit filed by the respondent. There is a reversing suit filed by the respondent, my lords.
The matter is taken up for hearing, for admission.
The suit filed by the respondent, my lords, is a permanent injunction and recovery of possession, my lords. And issue was a framed, my lords, by the page number 10, my lords, page number 10 on the brief. That whether the plaintiff are entitled to permanent injunction against the defendant, and whether the plaintiff are entitled for recovery of possession of the suit if he occupied.
But who are you?
I am the.
You are defendant number 1.
No, yes, I am the defendant number 1.
And defendant number 2, who is he?
Defendant number is the son, my lords, adopted son.
Adopted son of whom?
Adopted son of the defendant number 1, my lords.
So what is the relationship between plaintiff and defendants?
Plaintiff is a dear of house.
Plaintiffs.
Plaintiff was the son of Dhoya Samar, is the adopted son, my lords. Adopted son.
So what happened?
Then, my lords, then the issue was a friend, my lords. In the issue number of page number 10, my lords, page number 10. Whether plaintiff are entitled for permanent injunction against defendant, and whether plaintiff are entitled for recovery of possession of the suit land. And that has been answered, my lords, at page number 15. Page number 14 of the brief. Documentary evidence adduced by the defendants. When the plaintiff had a suit for permanent injunction and recovery of possession, if occupied, it is incumbent on the part of the plaintiff to prove both titles as well as possession.
Dismissed.
The suit was dismissed, my lords. Then, my lords,
appellate court,
my lords, even though the issue was not for adoption, the appellate court, my lords, at paragraph number 12 of the judgment, page 25.
Yes.
Page 25, paragraph 12. As it appears, the Lorraine Trial Court felt in its duty to frame issue as to whether the plaintiff number 2 is the adopted son of Bika, whether the defendant number 1 is the legal married wife of Bika, and whether the defendant number 2 is the adopted son of Bika. Having respective pleadings and the counter pleadings, the parties have adduced evidence on those points, and the evidence on the score is sufficient to come to a definite conclusion on such issue. Therefore, there is no impediment to decide such issue at the appellate stage without remanding the matter to trial court, my lords. When the issue was not framed by the trial court, my lords, he has overcome to the order of that.
Order 41, rule 25. Forgetting.
That was neither the issue of the
23. Neon. Order 41, rule 23.
Yes, my lords. Then, my lords, even though the records were, that is the, my lords, that is, even though, my lords, the records, that is, my lords, at page 16, paragraph 16, the defendants has relied the Aadhaar card of defendant number Exhibit 1, his postal passbook. Both the documents have been prepared after institution of the suit, so there are no avail of defendants. However, in the voter identity card of defendant number 1, Exhibit C, she as wife of Vikas Samar. Exhibit C was issued in the year 1994 when dispute relating the status of defendant 1 had not arisen. The defendant number 1 had also described as the wife of Vika in your widow pension card and her identity card Exhibit G issued by the Women and Child Development Department, Bhubaneswar. Both the documents are public document and the authorities concerned to discharge of their official duty after verifying the status of defendant number 1 have issued the same, the original ration card. And my lord, that is, even though the registered adoption deed is there, that was not accepted, and the suit was allowed in repeat, my lords. The suit was allowed part, my lords, that is in respondent number 1. So in appellant number 1, my lords, that is appeal, my lord, that is appeal is allowed on contest against the respondent. However, under circumstances which cost, the judgment dated 9/10/2013 and decree dated so and so, passed by the second additional civil judge Bhubaneswar, are hereby set aside. The suit is decreed in part. The defendant number 2 is permanently injuncted to enter upon the suit properties and disturb the possession of the plaintiff in any way.
Heard Sri D.K. Ponda, Reverend Counsel for the appellant, peruse the impugned judgments, considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. One, page 6 law, C regulation, along with other consequences will be given a go by. Will be go by will be given a go by, even if there is formal giving and taking ceremony, has not been proved. Then E is wrong. He has filed recovery of possession alternatively. That has to be, he claimed that claim for confirmation of possession in alternative, recovery of possession is also always claimed. So that both can, so in alternative prayer, he can make an alternative prayer that if he is found to have been dispossessed, the recovery of possession, that can always be made. G you should notice the respondents by registered post with AD, returnable within 4 weeks. The requisites be filed within 3 working days. Call for the LCR matter in the October. In the week commencing 7th October. In the week commencing 7th October. Yes. I don't know, 14.
Please, your lordship. My lord, there is a defect, my lord, regarding that I have not filed the certified copy of trial court judgment and decree. If your lordship is permitted, the certified copy is with me. Your lordship is permitted to file the certified copy.
Is this matter? Learned counsel for the appellant undertakes to file the certified copy of the judgment of the trial court by tomorrow. If the certified copy is so filed, is this matter for admission next week? We commencing 12th August.
Who bless me?
I don't know, 15.
15, my lord.
Same.
My lord,
I have again certified copy of trial court judgment not received.
My lord, I have filed the miscase for dispensing with that has not come.
IA 964 of 2019. Certified copy of the judgment of the trial court is dispensed with for the time being.
My
yes.
And my lord, I have filed a IA for stay, my lord.
Has it been admitted?
My lord.
Has it been admitted? It has not been
No,
admitted.
no. It is not. No, my
lord.
No.
Admission.
My lord, that may be come next week.
Next week also? Is this matter in the week commencing 12th August for admission?
My lord, along with IA 291 of.
Along with IA number 291 of
24, my lord.
It's on 24, yes.
Oh, bless.
Item 16.
Second appeal was admitted. The order dated 30/11/21, my lord. I have filed an application for stay of final proceeding, my lord.
All right. Has anybody appeared?
Yes, they have appeared.
1 and 2 have entered appearance to the advocates Durga Prasad Patnaik and S. Mishra. Nobody is present. We'll pass it over and we'll pass it over. Hakim, without they have appeared in the stage.
Final degree proceeding ta stay hawani. Appeal ta admit heichi.
No pare. और stay करे बाध्य ना करूँ. Stay करे बाध्य.
Second appeal ta kahi rahibo.
इसमें से जो कौन है? What I'm saying is that somebody has appeared.
Because of the
somebody has appeared for the other side. I want to hear. That's the same order. What order will be passed? It will not be sealed and signed.
ଆଜ୍ଞା ସେଇଆ କାହିଁ anxiety କି ସେମାନେ ଆସିକିରି ଜମି ମାପାମାପି କରୁଛନ୍ତି ସେଇଥିପାଇଁ କା
I was just
seal and sign ଟା ତ stay ହବ ଆଉ କଣ you will proceed.
All right. Counsel for the petitioner is present. For the appellant is present. None appears for the opposite party. The respondents on repeated calls that IA record. in the interim, it is directed that the final decree proceeding shall continue, but the decree shall not be sealed and signed without leave of this court.
ଆଜ୍ଞା ଏଥର ଯୋଉ ପ୍ରିଲିମିନାରୀ ଏକ୍ସାମିନେସନ ହେଇଥିଲା ଆପଣ ସେ କ୍ୱେଶ୍ଚିନ୍ ଦେଖିଛନ୍ତି
Coup preliminary.
ଏଇ ଯୋଉ ଇଏଙ୍କର ଓଜେଏସ୍ ର
No.
ଭେରି ସରି ଷ୍ଟ୍ରିଟ୍
We'll discuss out of the court.
ମାନେ ଦେଖିବନି କ୍ୱେଶ୍ଚିନ୍ ନମ୍ବର 1 ଠୁ ଆରମ୍ଭ କରି क्वेश्चन नंबर सेक्शन 10 रे अपील हबना रिवीजन हबो ना कोन हबो सेक्शन 10 ता को एक्ट
ଆପଣ ଏମିତି କହୁଛନ୍ତି ଯେମିତି ଆପଣ ଭାବୁଛନ୍ତି ଯେ ମୁଁ କ୍ୱେଶ୍ଚିନ୍ ତିଆରି କରିଛି ବୋଲି।
ମୁଁ ଆପଣଙ୍କ ଆଗରେ ଅଭିଯୋଗ କରୁଛି
କାହା ପାଖରେ ଅଭିଯୋଗ କରୁଛନ୍ତି ଭୁଲ ପାଖରେ ଯୋଉ ଯୋଉ ରାଜ୍ୟରେ ଯାଇ ଯୋଉ ରଜାଙ୍କ ପାଖରେ ଆପଣ କରିବା କଥା ସେଠି କରିବେ
କିଛି ବି କରିପାରିବେନି
ଆମେ ଆଜ୍ଞା କେତେ 2009 ହେଲେ କେତେ 15 ବର୍ଷ ତଳେ ଆଜ୍ଞା ପରୀକ୍ଷା ଦେଇକି ପାଇଥିଲୁ ପରୀକ୍ଷା ଦେଇ
witness to that
you were witness
ଆଜ୍ଞା
no interview you were there
ଆଜ୍ଞା पर जे कॉन्स्टिट्यूशन रा 42nd अमेंडमेंट रे कोनटा आगे अमेंडेड हैला चारटा अछि चारटा रो अछि सोवरेन सोशल सेकुलर एंड मेलर आउडी कोन अछि
डेमोक्रेटिक रिपब्लिक
डेमोक्रेटिक नै
सोशलिस्ट तो अछि आउ को
सोशलिस्ट सेकुलर ए दीटा हिची डेमोक्रेट तो थिला आंसर होची चारटा को करेक्ट
Does this matter? Yeah, admission again for high hearing 7th October. Yes. Item 17. कितना चाहिए? Orders? Okay. Sir, कितना item कितने? 17. Okay. Item 17, yes. For substituted service of notice on respondent 1 and 2. In the meantime, they have already appeared through their counsel. All right. So, later on, admission.
Final, your lordship is directed for final hearing at this stage of admission.
No, there is no such order, Mr. Bhuya.
No, only delay has been condoned by the order dated 1/5/23.
1/5/2023. So it has not been formally admitted.
No.
Let us admit it then. Let us first admit it, and since he has appeared, you serve a copy of the appeal memo, we can hear it.
No, I am appearing for the respondent.
I'm sorry.
I am for the appellant.
So same. So admission पे को तो कौन अच्छी?
Sir.
We'll see. Once it has been listed, let us do whatever is necessary. Why wait for?
Sir, the impugned order, judgment and decree of the first appellate court in RFA number.
You forget about the number. Number. Who are you?
I am for the.
No, sir. Who are? mane which party are you?
I am for the petitioner appellant.
Sir, बुझ लीजिए अपन who are?
Minaki sir.
Sir, what were you in the court below? Trial court कौन थिले अपन?
Trial court sir plaintiff थी sir.
Sir अपन किए? अपन को ना कौन?
Upi Das.
How sir?
Trial court he was his father, her father were.
Because I find that there is some trust, isn't it?
Milord, trust is the respondent, milord. The property belonging to.
You are the plaintiff.
I am my father.
Oh, anyway. So you are representing the plaintiff.
Right.
All right. Sarath Chandra Sahu.
Sarath Chandra Sahu is the plaintiff, sir.
All right.
And he is the owner in possession of the property, sold property, and consolidation ROR was prepared in his favor. And this respondent number 1, Sai Educational Trust, represented through Rajkishore Pradhan, dated 24/7/2007, executed an agreement for sale for construction of a educational trust in the sold property. and subsequently 4 days after, he has executed a general power of attorney in outside jurisdiction. And after executing the power of attorney, he has alienated the sued property for the benefit of the trust as an attorney holder. And to his own wife, he is one of the trustees. So thereafter, that was assailed. And the civil suit number 222 of 2008 was filed for declaration of the unregistered agreement for sale, the power of attorney, subsequent deed as void, and for permanent injunction. That was declared by the trial court in its judgment, and subsequently the registered first appeal report, which has been set aside, and against the said orders, this in the meantime the recorded tenant died, and his widow is arrayed as appellant. So this regular second appeal is preferred on the ground whether the person who has executed a unregistered agreement for sale before 4 days and thereafter executed a general power of attorney in outside jurisdiction and sell away the land for the benefit of the trust, not for the benefit of the principal. And the first appellate court negatived the set aside the judgment which was affirmed by the trial court, for which the regular appeal has been preferred. There is a substantial question, number of questions of law has been framed. My humble submission, this may kindly be admitted.
Why was the judgment reversed?
The judgment was reversed only on the ground that, sir, only that ground that was exhibited without objection. That you don't know. The trial court has stated no fraud has been
I am admitting it only on ground U. Ground U, and we'll hear it, Mr. Bhuya.
As your lordship.
Heard Sri. What is your good name, sir? Your good name?
Om Prakash Das, OP Das.
Heard Sri, you are in counsel for the appellant. Peruse the impugned judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial question of law. Page 16, draw U. No notice need be issued as the respondents have already entered appearance through Sri Vivekananda Bhuya, Learned Counsel. LCR is necessary. I don't think it's necessary. We'll call for the LCR. You have to verify that.
The original document your lordship has to peruse. The plea was
the LCR. Is this matter for hearing in the week commencing? The 1st October.
Sir, I filed an interlocutory application.
What is that application?
Sir, in the meantime, when the basis of the order of the appellate court, they have mutated their name and trying to create third party interest and also changing the nature.
So no third party interest shall be created. Where is that? Are you 1518?
18, sir.
1518 of 2023.
Possess me also nature and character.
That possession is with me. That is the finding.
I will only say that no third party interest shall be.
Okay, sir. Thanks.
It is directed that in the interim, no third party interest shall be created in respect of the sued property. Sued property till the next date. Yes.
Number 18. We can make called day after tomorrow. It will be nice.
Paso. Day after tomorrow mark कर देता हूँ. Item 19.
Item 19.
Please, Lordship, kindly grant some time for removing the defects.
Yes, yes.
Removing the defect.
कौन defect है?
Court fee देनी.
No delay as per बोला है.
Exempt petition.
Court fee of rupees 300 payable not paid. Court fee why now why exempted? Were you exempted in the court below? Who are you? The plaintiff?
No, the defendant, appellant, and here is appellant, my lord. That is corporation judgment, my lord.
Defendant is the appellant.
My lord.
On what ground are you claiming exemption?
No,
Yes.
exemption ତଳ court ରେ ହେଇନି.
ନା ନା ହେଲା ଡିଫେଣ୍ଡାଣ୍ଟ ଯଦି appeal ଫାଇଲ କରିଛନ୍ତି ତଳେ ବି ତାହେଲେ ତଳେ ବି ଆପଣ କୋର୍ଟ ଫି ଦେଇଥିବେ ବା exempted ହେଇଥିବେ.
Then I will pay it. Kindly grant some time, I will.
ଇଏ ଭେରିଫାଇ କରିନାହାନ୍ତି.
Exemption ପାଇଁ କି ହିଁ ଦେଇ.
ଆପଣ ସିଧା you started your submission by saying that you want exemption.
Yes.
Correct. So you should be ready with the facts. Whether you were exempted in the court below. Does the decree say so? ପଢି ନାହାନ୍ତି କୋର୍ଟରେ କଣ ପଢାଯିବ କୋର୍ଟରେ ପଢାଯିବ ନା ଆଗରୁ ପଢିଥିଲେ ଏଠି ହବ ଡେଲି ପରୀକ୍ଷା ଓକିଲଙ୍କର
କାଲି ଆସୁ I will.
ହଁ ସେ କାଲି ଆସିବ ଡେଫିନେଟଲି ରାତିରେ ପଢିଲେ ସକାଳେ ପରୀକ୍ଷା ଦେବେ ମତେ କାହିଁ ଏତେ ସହଜ ଲାଗୁନି ଓଡିଆ ଓକିଲାତିଟା ଆପଣ କେମିତି ସହଜ ଲାଗୁଥିବ ତାହେଲେ ପାସ୍ ହବ
କାଲି ଆଜ୍ଞା
ପାସ୍ ଓଭର ଫର ଦ ଡେ ପଢିକି ଆସନ୍ତୁ ଦିଟା କ୍ୱେଶ୍ଚିନ୍ ତ whether you are exempted in the court below. If not, then how can you maintain such an application before this court? If so, what on what ground? Yes, item 20. Appeal notice issued on respondent number 1C returned undelivered to the address is always out of station. Left without. Yes.
Your Lordship, I will take your Lordship.
Fresh notice. No, requisites for issuance of notice on requisites for issuance of fresh notice on respondent number 1 bracket small c be filed within 3 working days. Notice be issued by both ways. Let fresh notice be issued against respondent number 1C by both ways, that is registered post as well as through court process, comma requisites for which shall be filed within 3 working days. List this matter on in the week commencing 23rd September.
Interim order to continue.
Interim order to continue.
Order number 7, interim order also to continue. There are 2 interim orders.
Both the interim orders will continue. Interim orders passed earlier shall continue.
Okay.
Item 21.
Q1, there are respondent number 2.
Mr. Bhuya, I'll take up this matter tomorrow. What I will ask, what I will request you is to give a chart because there are a bunch of substitution applications.
Substitution will not be made, my lord. Why? The death was occurred in the first appeal stage. So, as your lordship, what I am just.
But all these applications have been filed?
My lord, it is filed.
You need a bunch in 1, 2, 3. Of these applications have been filed.
My lord, your lordship may kindly see the date of death.
Date of death is during the first appeal.
During the pendency of the appeal.
All right.
And the appeal was abated against them. Now, your lordship is to consider the effect. I have given the decision, your lordship may go through it. We will press it tomorrow. This has been
old decision.
Lord?
Old decision. What was decided here? If it is abated in the...
If the death occurred and the abatement took place in a particular proceeding, that court is only empowered to deal with the substituting asset abatement, not the appellate court.
Okay.
That has been decided considering all the Supreme Court decision.
So what order can be passed in this appeal then?
The effect will be considered by your lordship at the stage of hearing because that decree may be a nullity on this sole ground.
No, so what order can be passed then?
This your lordship may go through that.
I will.
So my submission would be the effect of death will be considered after appearance of the parties in the because one of the person who has succeeded in the suit, he also died. One of the respondent who suffered the decree, 2 of the respondent who suffered the decree, they have also died. So there is no surviving decree. In fact, your lordship will consider
why did you file these petitions?
my lord, it has been filed by my office, but your lordship, I cannot clear
You would
the
not,
defect.
no, you
It
will
is in-
not press these applications in view
My
of this.
my lord, that your lordship may go through. I will only pray for
କାଲି ଆପଣ ତ ଇଏ କରିବେ ଆଉ ବହୁତ-
ଆଜ୍ଞା।
All right, pass over, ରଖ। ଏଇଟା ଆମର ରଖିଥାଅ। ନହେଲେ ଆପଣ you take it back tomorrow you place it. Place the relevant paragraph so you have another copy.
Yes.
So tomorrow you place it. Item 22. Address refused. So that will be sufficient.
Limitation notice ଯାଇଥିଲା
Notice on respondent number 3 and 4 na?
ଆଜ୍ଞା
Notice 3 and 4 has returned with the endorsement addressee refused.
ଆଜ୍ଞା
Hence, such notice is held to be sufficient.
5
Insofar as 5 and 6 they are not see the corona. The postal tracking report in respect of notice issued on respondent number 5 and 6 be tagged to the case record.
in fact actual one against ଯାହା ବିଚାର ହବ
Notice ଯାଇଛି ଯେତେବେଳେ ତାକୁ ଯାହା ତ
ନାଇଁ ରେସ୍ପନ୍ସ ମୁଁ ବି ଏଇଟା 10 ବର୍ଷ ପରେ ଫାଇଲ କରିଛି ଅପିଲ କାରଣ ଆଜ୍ଞା ମୁଁ ତଳ କୋର୍ଟରେ ଅଛି ମୋ ବାପା ମରିଯାଇଛନ୍ତି ଆଉ କୋର୍ଟ ସେଟେଲ ବି ସେଇଆ ଅଛି ସନ୍ ଅଫ୍ ଲେଟ୍ ଅମୁକ ନୋଟିସ କିନ୍ତୁ ଜାରି ହେଲା ଘୋଷଣାରେ ଲେଖା ହେଇଛି ଯେ ତାଙ୍କ ଜଏଣ୍ଟ ଲିମିଟ ବାପାଙ୍କ ଉପରେ ନୋଟିସ ସର୍ଭିସ ହେଇଛି ମୁଁ ସେଇଠି ବି ଆନେକ୍ସର କରିଛି ମୋ ବାପା ତ ଆଗରୁ ମରିଯାଇଛନ୍ତି ଲେଖା ହେଇଛି ତାଙ୍କ ଜଏଣ୍ଟ ଲିମିଟ ବାପାଙ୍କ ଉପରେ ନୋଟିସ ସର୍ଭିସ ହେଇଛି
ପୋଷ୍ଟାଲ ଆପଣ ଆମ ପ୍ରୋସେସ ସର୍ଭରଙ୍କର
ମୁଁ ଡେଥ୍ ସାର୍ଟିଫିକେଟ ଦେଇଛି
ସେ କାହାକୁ ପାଇଥିବେ କି କାହାକୁ ବାପା ବୋଲି ଭାବୁଥିବେ
ସୁଟ୍ ଫର ପାର୍ଟିସନ
But କଣ କରିବା so this will come next week ହେଲା this matter next week
ଆଜ୍ଞା
let the postal tracking report be considered and thereafter yes 23
Item 23.
AD of appeal notice not back from 346 postal tracking reports are P, Q and R. Okay, let's see the postal tracking report. Delivered. The postal tracking report shows the notice issued on respondent numbers 3, 4 and 6 as delivered. What notice was this?
So your appeal is admitted by order at
Admission notice. Okay. There is however no appearance. Is this matter for hearing in the week commencing? All have been served.
No, sir, except 3, 4 and 6.
3, 4, 6 are sufficient allowable. Since all the respondents have been served, is this matter for hearing in the week commencing
30th September.
30th September. Interim order to continue.
Okay.
Item 24.
That's all the data now. One correct. Try to admission order.
ଦି ଦିନ ଡିଲେ ଅଛି
Notice ଯିବ court fee exemption କଣ ଭାଇ
ଟିକେ କୋର୍ଟ ଫି ଟା ଟିକେ ଦେଖି ଦିଅନ୍ତୁ ଡିକ୍ରିଟା ସିଡ୍ୟୁଲ କାଷ୍ଟ ସାର୍ଟିଫିକେଟଟା
ଦେଇଛନ୍ତି ତ
ଆଜ୍ଞା
ତ ଇଏ କେତେ ସେଟା
ଆଉ ଏଟା ନମ୍ବରଟା
811 ନା 9
ଦେଖିଲ ଇଏଟା
since the since the appellant belongs to the scheduled caste community and was exempted from paying court fees in the trial court. Has it been mentioned in the decree?
ଆଜ୍ଞା ଡିକ୍ରିରେ ବି ମେନସନ ଅଛି ଟିକେ ସାର୍ ଦେଖିବେ
In the decree passed by the trial court, court लिखा था the trial court.
Page 65 there.
I've got it.
Okay.
The trial court. Come on. Payment of court fees is issue tapra IE 811 of 2024. Issue notice to the respondent by yes.
My lord and friend, question ଯଦି କ୍ରିମିନାଲ ଏୟାର ହେଇଥିବ ସିଡ୍ୟୁଲ କାଷ୍ଟ କହିଲି ସିଡ୍ୟୁଲ କାଷ୍ଟ ତ ଏକ୍ସେପ୍ଟେଡ୍ ଆଉ କ୍ରିମିନାଲ ଏୟାର ସହିତ କଣ
Criminal. He is reading recent judgments. Mr. Das has been reading some recent judgments of the Supreme Court. That is why
Unless the notification issued by our
Seta Havandi. That is only in respect of the reservation of in employment. Only in employment.
only service.
But whatever as a group, whatever they are getting. So there's a very interesting question. Suppose sometimes we pose that at a bank not a writ application or anything like that.
No.
Respondent by registered post with AD requisite. Respondent by registered post with AD requisites be filed returnable within 4 weeks. Requisites be filed with this matter. What a date karo? In the week commencing 30th September. Yes.
Item 25.
I think 25, my lords, may kindly be passed over for the day, my lord.
All right.
Mr. NK Sahu is appearing for some unforeseen circumstances.
No, but the IA was for filing of certificate.
Certificate copy it has already been filed. Well, there's no
IA 618 of 2024. Since the certificate copy has already been filed, the IA has become infructuous.
I will pass over for the day.
How can you pass over? Well, I release this matter in the week commencing so and so for admission.
Lord, shorter date can have asudha actually in this matter.
Yes.
Asudha.
कर दो ना कोटा next week कर दो ना
Next week.
Is this matter in the week नहीं था pass over था कल नहीं किया
Let pass. Obligation.
ये और का पास नहीं की कल ही रे यहाँ तो कल ही यहाँ का सिस्टम पे और का दे दो तब एडमिशन का
Obligation.